ছেড়ে চলে এসছো এখন মানে কি করে শুনবো? কোনটা এসছে? কোনটা হচ্ছে এটা? ইভেন্টের লিস্ট করলে তো নিজের ব্যাটারি শোনা, তাই না? ওদের সাথে আর কেন দেরি হলো কেন গো? কেন দেরি হলো কেন?
We mentioned, my lord, an order was passed by the Honorable Justice Vishwadip Boshu in Court number
Are you
9
in person?
in person.
Yes.
So he gave me relief, interim relief till the end of this month. But the problem is the order clearly said that the matter should be listed in the combined monthly list of November, but it did not. So
You mentioned before the regular bench. There is no urgency in the matter.
there
There is no urgency in the matter mentioned before the regular bench. Yes.
The trial court order is matter
Interim
is
order
listed
is
on the
valid.
59.
Interim order is valid.
It's valid,
Val-
but the order, but the court is returnable on the
regular
29th.
bench.
My lord,
Yes.
Urgent matter relating to the list of Honorable Justice Chaudhary. Matter relates to extension of interim order. Order ends up November 2024.
Already lapsed.
November 2024 up to 30th November 2024.
Oh, it's there. Next.
May I have lots extremely urgent new motions made of my Lord Justice Raja.
What is the urgency?
But urgent is regard to this matter the front, which cannot be converted to a vastu without any due process law under section 40 of the West Bengal Land Reforms Act. Now the some persons of that front has been taken steps without taking any course of law. They are filling up the pond. And also we have already complained. And this regional applications filed before the DLL.
What is the order impugned?
Order impugned is the district land and reforms officers in 2022. That was passed. During the pendency, my lord, they did not.
No, what is the determination? It's arising out of a suit. Application arising out of a suit.
It's a new motion. In connection with the appeal.
Determination to করবো determination to
Item 227.
রাজা determination to করবো
Raja Boshu Chaudhary.
কালকে লিস্ট হবে
Page also given.
This is civil revision.
Civil division. 227.
That is revision. It is.
It has already been listed of my lord Justice Basu.
Listed.
My lord, already listed as serial number 227 of the last Friday.
দেখো না
Civil division আছে
লিস্ট করা আছে বলছে 127 127 বলছে সিরিয়ালি লিস্ট করা আছে ওই কোর্টে লিস্ট করে দাও মোশনে কালকে tomorrow. কালকে ওয়েডনেসডে। আজকে এতগুলো কি করে নেব? সেটা হয়ে যাচ্ছে। How many matters are there?
Pardon?
How many matters are there?
There's only one my. My matter is
You say 1 to 7 has been listed?
no, no, 227.
How many?
227 serial
Then
number.
there is 5 matters.
The day list on Friday. 227 of the civil agent.
No. Also urgency. তুমি সাপ্লিমেন্টারি লিস্ট করে 12টার পরে লাগিও না। 12টা 12:30। 12টা টাইম দিয়ে দাও। বাকি তাহলে করবো না বিরাট। ইয়েস।
এখানে লিস্ট হবে 12টার সময়।
I was praying for whether to file a single application without the typed copy of the certified. I have the certified copy, but there are about 100 orders which are handwritten. The department is asking for typed copy of those orders. She can't sleep to file it without the typed.
Is legible.
It's legible. And
Give-
an order kindly says. The orders are very much legible, my lord. But since they are handwritten, my lord, department is refusing to accept it.
Since what is the reason?
My lord, it's a order, my lord, passed by my lord Justice Vishwadeep Basu that until the court grants leave to file, all handwritten orders should be typed. But there are about 100 orders, my lord, which are handwritten. Typing is very difficult.
Leave grant.
My lord, may I be mentioned, my lord, saying leave my lord to file with the server copy of the order, my lord. I have applied for the certified copy, but the department says, my lord, it took some time. And in the meantime, police help order has been passed without, my lord, beyond the decree. And my lord, prayer also not made to get police help against me, my lord. Kindly,
দেখি application.
my lord, I have folded that page, my lord, of their petition they have prayed. Annexure E, my lord. I have folded that portion, my lord.
Where is the application for getting the certified copy?
My lord, at the last, my lord, before this Allotment.
Get the certified copy and then file.
But may I be permitted to mention a matter for extension of interim order relating to the list and determination of Justice Vikas Ranjan. The interim order will expire on 30th. My lord,
Afterwards. Mention afterwards. Yes.
Kindly to mention a quick revisional application. My lord, the interim order was valid till Sunday. I have mentioned the matter before Justice Basu Chaudhary on Thursday. Matter was to be listed on Friday. When it was not listed on Friday, I have again mentioned the matter to be listed before him on the same.
Who is on the other side?
My lord,
They have appeared.
they have not appeared.
Given. It has expired.
But on Sunday.
Sunday.
Sunday, because I couldn't move the I couldn't have my pension yesterday. But the interim order I carried. But I said, it's a order of the district magistrate which was challenged. It was an order of a district magistrate which was challenged before the debt recovery tribunal. Debt recovery tribunal did not grant us any interim relief. Against that, we preferred a appeal before the debt recovery appellate tribunal. Debt recovery appellate tribunal.
Extension দাও।
My lord, the interim order granted is likely to expire this week. Therefore, it is within time. So, my lord, the interim order granted,
Afterwards. Not today.
Friday it will expire.
Not today. I will not take it.
Mention one matter for extension of interim order, which is going to expire on 30th of November.
Not now. Not now. Next.
Extension of interim order.
Not now. When? 30th.
November,
The 30th of November also for me, my lord.
My lordship, may I be permitted to mention one matter? This matter has been pending since long time, and the matter is a matrimonial suit where the petitioner was requested for transfer of the jurisdiction of his landed court. As she is a poor lady and presently living with her minor son, it is extremely difficult for her to travel to the court proceedings, and thus for the my lordship kindly hear.
Not now, no urgency. Not
But
now.
may I be permitted to mention one matter, my lord? I am mentioning for inclusion of one application relating to the extension of interim order, which has been expired already. My lord, the petitioner is surviving under the great difficulty, my lord. She is a cancer patient, my lord, and this is a section
When
20.
did it expire?
Actually, my lord, it was expired yesterday, my lord.
Give.
Great.
My lord, may I have?
What is the order impugned? What is the order?
Lord,
No. No.
Lord, may I have your lordship? Kindly, Lord, I want
No.
to file this petition before in this bench. Lord, it's a 24 application, section 24 application. The lady resides in Dum. And Lord, the proceeding is pending before the Shiliguri court. Lord, she is in such a deserted condition that she cannot even go to the circuit bench to file it. So, Lord, leave is required to file it before this court.
She is residing in? Residing in?
Malad?
Where?
Dum. She is residing in Dum. Proceeding is Malad in Shiliguri court, but the lady's condition is such Malad she cannot go and file it before the circuit
She
bench.
has to take
And
the
that
pen.
is why leave is required to file it here
No.
in this
No.
bench.
Yes.
Directed to disposal of it. 30 to 35 days have been nothing, no progress on the file.
What is this matter? Expeditious disposal of the suit next week.
I'm
Not now.
My lord, I am suffering an order of injunction, my lord. No, there is no specific prayer for partition, my lord. But the matter needs urgent hearing, my lord. My construction is stalled, my lord.
Huh.
My lord, the matter is pending before Honorable Justice Raja Basu Chaudhary.
It will be hard, no. No
Well,
urgency
but
right
can
now.
it-
No.
Lordship, if you permitted to mention a matter, Lordship, one civil revision has been filed to the Honorable Court, and subsequently, due to the some difficulty of the advocate, the CO was dismissed and one restoration is filed. But what has happened, in the lower court, one application under section 45 of the Guardian and Wards Act has been filed by the opposite party, and the date is fixed today in the court below. Now, the difficulty is the court, the learned law is not granting us any stay or adjournment since it is still pending before the honorable court and it has not been heard till date. So, Your Lordship, I'm praying if the restoration application can be included in the list so that it can be heard and the CO can be restored. It's an urgent hearing.
It is of whose determination?
Lordship, now it is pending before Justice Rajabhasu. But Lordship, the date is already today in the lower court and it is not granting us any stay, any adjournment, nothing as such. And it has not been heard and the CO needs to be restored.
The other side has appeared.
Lordship, the CO has been dismissed, Lordship, so it could not be served on the other side. The restoration has to be heard and it has to be then restored back.
The difficulty is I have been given determination for today only.
Lordship, but the difficulty
The file is not here.
the court below is today itself, Lordship. I had already appeared for the mentioning court number 23 also, but since it's not sitting, and then today I had again for your
So you do one thing, you come tomorrow.
Lordship, for your
The application to another. There is a restoration application.
Lordship. It is pending. And the difficulty that the it's not granting. The restoration is also pending of
Because civil revision is not now not pending.
That's the difficulty, the league is suffering for that. They have also
Come tomorrow. If this determination continues, I will take it up tomorrow. Come mention tomorrow.
It's a civil revisional application challenging a proceeding before the National Company Law Tribunal, where an execution application has been filed of a demand letter. There is no order or a decree. Well, we have challenged that by filing our objection, but on oral mentioning, without notice to us, the direction has been passed to file affidavit of assets in an execution before the NCA. Now, my lord, we have taken a recalling application, but without hearing that, we have been directed to comply with the. But from that, we have challenged. When the matter is appearing in NCLT today. So, my lord, we have been trying to mention yesterday also. My lord, if it so commences to your lordship, kindly takes it up tomorrow, my lord. If your lordship's determination is there, I'll give the slip. If it is there, my lord, if it could be included
Tomorrow.
If your lordship determination is there, otherwise, my lord, we shall try our luck. Because the urgency is that, my lord, they're proceeding without my application.
তাহলে mention করে রাখতে পারবে? Mention tomorrow then, huh?
Then if need be a supplementary list.
If the determination continues, mention tomorrow because they will need some time to bring the file or not. So make a supplementary list and then hear out. Tomorrow you mention.
The problem is the matter is there today. So, my lord,
Tomorrow come
it could
tomorrow.
be today's supplementary is subject to my lord's business. I do not know, my lord.
There are other matters which will be listed, come tomorrow.
My lord, may I be permitted to mention a matter for extension of interim order, your lordship?
No urgency right now. Yes.
Can I be permitted to mention a matter for extension of it? This is from the list of justice.
When it's to expire.
The same is due to expire on 30th of November.
Not now. Yes.
Lordship, this is an civil division application order passed by Vishwajit Basu and extension of interim order, which ends on 30th.
But my agency is this ballot and exhibition case is going on. My stay has been vacated by it. The condition given by the court ballot that I have to pay 8,000 per month ballot and I'm also back with this ballot. Now, my lord, I have.
He has been vacated by whom?
By my lord, the court level. Now there, I was enjoying a stay order on the court level on execution case ballot. But I'm a tenant ballot. This tenant land court dispute ballot. I had filed a suit ballot declaring that my tenancy right is there. And my lord, I was granted stay order by the court level. Now subsequently, my lord, the petitioner ballot filed an application ballot where my lord he had asked for occupation charges. Now that occupation charges ballot was given ballot it was raised to an exorbitant amount ballot from 800 to 8,000. But I challenged that. So that was pending ballot. That ballot, when that was not taken up ballot, I filed an application to the court level asking that without prejudice to my right in contention, I am depositing 8,000. Once ballot 8,000, I've already deposited ballot. Thereafter, I said that kindly accept this, and if this ballot I can bring different order from the High Court ballot, then I will continue to pay that ballot. Now that application was rejected by the court level, and ballot my ballot the stay ballot was also vacated. My addition ballot I can be executed anytime. That's my problem. I need to take it up.
When is the next date of execution? When is the next date?
Date fixed ballot on December 4th.
Next.
But
arbitration execution case ballot, we had filed an application under section 47 for not challenging maintainability of that. But that application has been rejected. But we have sought an adjournment. But 29th has been kept as a last chance. Unless this application be heard, this
the other side has appeared.
They have filed caveat. We have informed them that we will be mentioning this matter. But as a last chance, otherwise special.
29th.
29th. 26th. We are sitting.
Okay. 28 तारीख mention करते हुए 28 तारीख if this determination continues on 28th you mention you can have a supplementary list and hear out the matter but given prior notice. No. No, I am sorry.
I need to mention a matter for the extension of expiring on 30th of November.
What?
That may have a extension of what is expiring on 29th of November. This matter is, I thought just Raja was
Not now.
But matter of extension is
One matter, your lordship.
for the lower court is for date in December.
All right.
They are permitted to mention on group 1 matter, your lordship. The land of the petitioner has been acquired, but I have not yet received the compensation. He is an octogenarian, your lordship.
Year is that
2015.
But yes. come afterwards. If this determination continues, I will take it up, all the extensions.
Of Honorable Justice Rajabhasu determination, my lord, is regarding the vacated, the stay has been vacated by the London Appellate Court. Assailing the said order, my lord, I am appealing the said order. Can this be taken up, my lord, otherwise? My lord, regarding the interim order that has
Not now.
already affected, my lord, kindly,
Not now.
car will be convicted, my lord.
Not now.
It's a revisional application, which was, our arguments were complete. It's regarding, it's from an order rejecting our application for additional documents.
Order 41.
Order 11.
Order 11. Hear it out before that bench. That's all.
May be permitted to mention, my lord, mentioning from the list and determination of Honorable Justice Basu Chaudhary, my lord, this matter was last heard before the puja vacations. However, it was directed to be included in
is
the
it?
month. My lord, the opposite parties are enjoying over my property over 60 of 80 crores over 6,000 square feet without paying a single rent. My lord, kindly includes this matter in the
What
list.
is the order impugned? What is the order impugned?
My lord, this matter was last heard.
What is the order impugned?
My lord, the matter was last.
What is the order impugned?
My lord, this matter was.
Against which order you have come up before this court?
My lord, this is the civil revision for.
No urgency.
My lord, may I be permitted to mention a matter, my lord? My lord, the extension of interim order, I understand your lordship is not taking it up for the 30th extensions, my lord. My lord, if your lordship determination continues, kindly give me liberty to mention tomorrow, my lord.
Liberty
This is the
granted.
extent.
If
I'm very
it is
grateful.
so, on 30th we can take it up.
I'm very grateful, very grateful.
Item number 1.
অদ্ভুত ব্যাপার।
এই, এটা কি হলো? Your report?
But not if but as report has come, my lord.
What was the direction?
Not above your lordship, allow me some time, my lord, then I shall file by.
When? Tomorrow?
Report has come. They will come from the.
Okay, let us hear him.
My
You
lord,
will
only
get
I
your
have
time.
one
At that time, you file and make your
I
reply.
have one submission regarding this. My lord, I need to get hold of this report in the form of affidavit because I may prefer an exception to that report. Why I say so? Because it was an arrangement between the state and the West Bengal PDCA regarding their application. So since they were the authority to act.
Where is your affidavit in opposition to the application?
No, I am not being able to do it because I need to see the stand of the state. It is important
Affidavit
for
in
us.
opposition against their application seeking leave to bring on record certain facts.
Yes.
Where is that affidavit?
They have only brought that the subsequent development, they are going to install the solar power panel.
Not pressing anything on his petition on a demurrable point, I shall argue. I will not press any action.
But I need to, my lord, the report is to come from me because if the report, I do not file an exception to the report, if there is something adverse,
I will go
then
back.
I'll be in difficulty then. Because what's the state stand, I do not know today. Because they were the acquiring body.
When the last order was passed, you never submitted that you will be filing any exception to the report because this direction was way back in the
lordship. Last occasion directed to file affidavit, not previously. So unless they give it to me, I do not see what stand they have taken.
Well, I shall go by demur as if all the statements in the petition are true and correct. I will like all the
I need to understand the state stand. What they are the acquiring, what they are the acquiring body. Now I need to understand what stand they are taking, unless it will be prejudicial for me, because I am not getting any opportunity to controvert their allegation, because they are in the same boat basically. They have acquisition given it to the thermal power station. Now the issue is that for 1966, since they have acquisition was done, one portion of the huge land, few portion of the land has been acquired, utilized, rest is not utilized for more than 50 years. Now we have been calculated.
I will admit that's
Very well, but I need to see what stand they are taking with the
case.
your lordship. There is a direct, my lord. I am being prevented. I am being prevented. Well, I'm very sorry. There is, your lordship, there is a specific direction of the state to file affidavit. There must be some reason your lordship directed him to file an affidavit. Now I should get a chance to see what their stand is. I need, if it goes against me, I will go for an exception. Previous report.
The dates are being fixed one after the other.
Lord, I am
so
ready.
that the matter can be heard out.
Yes, my lord.
If you intend to take adjournment, then it's.
Lord, I am not taking adjournment. I have a right to know.
It is
what
not
to
that
say.
first time I passed an order for them to file report.
Yes.
This was never indicated by you in the last order they will filing any exception to the report.
I have filed.
I wouldn't have fixed this day today.
My lord, I have filed affidavit in reply to the previous report of the PDCL. It is not that I have not filed. It is on record. There is an affidavit
So,
in reply.
Bandopathy, when can you file it on the base?
I have no problem.
By Friday, you can file it? By Friday this week? By Monday? Monday, কত তারিখ?
Yes, I have no problem.
Second.
My lord, at least 3 days time be given. I'm not seeking 7 days time. 3 days time be given to give response to that if it is adverse. Then my lord fixes any date. I'm not even seeking 7 days. Give me 3 days time so that I can prepare it. My intention is not to take adjournment.
Solar project is being held up.
For 2021, now it is so urgent. From 2021, it is held up. So 2017, I'm sorry, 2017 it petition.
No, because we are setting up this project and there is no bar. There is a status quo regarding possession. Without parting with possession, I'm setting up this project. But showing this, they are instigating the people not to.
Possession is with us. We are cultivating. We are farmers over there. We are being dispossessed. You know, lordship.
I will meet
the
that
fly
point of
ash.
law. I'll
The
meet
fly.
that point on law.
My
lord, the fly ash is being deposited.
Because
my lord, one submission.
I'll hear out this matter. They have mentioned.
I need to. And my lord, only one thing. The
তারিখগুলো
fertile land.
তারিখগুলো বলুন। By 2nd December, you file your report. By 6th December, this matter will come up. By that time, you file your.
Let them give an advance copy of the report. Let them give an advance copy now, here and now.
My lord, no, I need to take the affidavit. My lord, kindly tell them to serve an advanced copy upon me on Monday itself.
Let them give a copy just now.
Definite date বলুন 7, 6
I will respond to the affidavit, not the report. Yes, yes.
আগে থেকে ডেট টপিক দিয়ে দিন। বেশ ঠিক আছে। 6th December. Mr. Bandopathy, learned advocate for the state respondent 6 weeks time to file its report in the form of affidavit. Let such a report in the form of affidavit be filed by 2nd December.
Report nahi diye din na report.
Exception, if any, to such report be filed by 6th December.
Yes. No, amake.
Yours is 2nd December. He will
Yes,
file
yes,
by
yes.
6th
3 days.
December.
I'm not seeking
6th itself, I don't need
Oh.
to see the rejoinder report.
List this matter.
My lord,
6th
only,
December.
my lord, only one thing.
6th December. Advance copy of the report be served upon learned advocate for respondent number 7 as well as the petitioner. Yes.
My lord, I am the advanced copy be given me on Monday itself. On Monday itself. I need to respond to the paragraphs of the affidavit. Now, my lord, because my clients are from Purulia, they're the farmers. I need to call them and bring
Sir,
them.
if he files on 2nd,
Yes.
the matter will come up on 6th. That means you are getting almost 3 days to
That's my request
read
with
out
your
what
lordship,
is
so
being
that
stated
a
in the
copy
report.
may be given on 2nd itself. 2nd itself. That is my prayer. So if
Give
I
it.
get it on 4th, then 6th will be difficult for me. Yes.
By
that's-
2nd, you will get that.
Yes, yes, I'm seeking that only. I'm nothing.
6th December.
6th December, very well, my lord.
Same, my lord, same.
It will come top. Yes.
Yes, but আপনাদের একটা
My lord, my lord, just my phone. My lord, any order till now, head of the
My lord, only one thing. Joshua দাঁড়ান আরে জোসেফ একটা অন্য
Court number 5, I cannot understand whose determination.
My lord, may I, done. My lord, my lord, I missed the chance. My lord, I frankly confess, my lord, because matter was called on. My lord, I was rushing. My lord, only thing, my lord, urgency regarding revision application was taken by the Honorable Justice Rajabasu Choudhury.
Correct.
There is an urgency, my lord. So for my petition, my lord, I cannot run my business. They stopped my. I am being a teen. Because, my lord, I got an order from the lower court, my lord. They filed a revisional application. They obstructed me like anything. I want to hear out the matter.
Not
My lord,
now.
so that, my lord,
Not now.
because
No, Mr. Sinha, not now. No urgency.
no urgency, my lord, they are
Mentioned before the regular bench.
my lord, they
Ah,
stopped
no
my-
other mentioning. Tako, listen.
Item number 2.
I come on Monday. May I come?
Sir, the difficulty is at the time of mentioning you were not there.
My lord,
I have stated to the advocates that since this determination of, understand this, since the determination for this day, the interim order which is to expire on 30th, you mentioned prior to that day or on that day, a supplementary list will be prepared for extension of the interim order.
Yeah, only
Have you understood? Not tomorrow. 30th, if it is 30th, then come on 29th or on 30th. I'll make a supplementary list of the extension and extend the order. I have been given determination for this day only.
May I get one interest?
Tomorrow mention. Sir, list has been taken up now. It is mentioned tomorrow.
I will mention on tomorrow. I am taking that. I will mention. I am taking that. Yes. That my lord always will give me. My lord, always. My lord,
Yes,
unless
next.
urgency is given, my lord, I cannot.
On the clear process. Who is for the petitioner?
My application for subdivision and restoration. So I appear for the National High Court.
No, there are 4 applications.
For it.
Which one is
One is subdivision of exhibit number 1.
substitution comes later on, which is the application for restoration.
The applications have not been served upon us. Yes, I have served by post, my lord. I filed the appeal service.
You are appearing for?
National Authority respond.
Give the copy. Give a copy of those applications.
Then I will serve, my lord.
Mr. Dipankar Das, learned advocate appearing for respondent NHAI, submits that the copy of the applications submits that the copies of the applications have not been served upon him. Learned advocate for the petitioner is directed to serve all the copies. Directed to serve copies of all the applications upon learned advocate for respondent NHAI. Please this matter on. Release this matter after 1 week. Go through the applications and make your submissions. You intend to file any opposition?
For the applications of.
Okay. Direction দিয়ে রাখো. He seeks to file. ওখানে ওনার submission Mr. Das's submission শেষে বলবেন he seeks to file affidavit in opposition. Date such affidavit in opposition we file within a week. Reply you record to file? No. Okay. Within a week. Please this matter after you go through that. If it is required, then mention on that day. After 1 week. 6th December. Matter will appear on 6th. Yes.
Item number 3 for KMDA, my lord, led by Mr. Soturi.
After recalling of lordship's order, my lord. Right, my lord, to the
Dated
dated 15th May. Immediately after my lord dismissal, I think
recalling of which order?
yes, but your lordship's order, my lord, dismissed for default. 5/2024.
15th May. নিশ্চয় বল- yes. Recalling is 2. It is within time. This is an application for.
My lord, kindly fix it by second week of December.
This is pleadings are complete.
Yes, affidavits are received.
This is an application for the restoration of the writ petition by recalling order dated 16th May 2024. Where is the ground? Which paragraph? Mr. So and so learned advocate appearing for the petitioner submits that on the date the matter was called on, my name does not have Ranjan. I do not have Ranjan. You have mentioned in para 6 my name Ranjan. On the date the matter was called on, bracket in there, that is 16/5/2024, the learned advocate on record for the petitioner was not present in court due to his illness. He seeks for restoration of the writ petition by recalling order dated 16th May 2024. The learned advocate appearing for KMDA, respond number
5
KMDA, does not raise any objection. Considering the amendments made in the application and the grounds therein, it is found that the cause shown is sufficient. Accordingly, the order dated 16th May 2024 stands recalled. The writ petition being number 9104 of 2008 is restored to its original file and number. Both the learned application being can 2 of 2024 stands disposed of. Both the learned advocates submits for fixing the matter for final
second week of December. Any date?
release this matter after কত week আসছে second week after 3 weeks 3 weeks হলো কবে আসছে 18th December
18 December.
এই নিন নিতে পেরেছেন
দিদি
Item number 4.
This is my reflection. When your lordship was sitting in that other building, my lord, this was substantially heard by your lordship. Led by Mr. Abhutosh Mujumdar, he was making a submission just to. The challenge to the writ petition is a demand letter by the respondent authority, claiming an additional charge on the land which has been allotted to the petition.
This is lease
Yes,
or on ownership. What is this?
but this is lease.
Lease.
But there's a demand for paying an additional amount of rupees 15 lakhs per acre, which is the subject matter of challenge in the writ petition. If your lordship kindly takes a look at My lord, the letter by which this was allotted to us and see the terms thereof. Kindly comes to page 37. Kindly comes to page 37.
Hmm.
You will find that 50 acres of land was allotted. May I place it? With reference to the above, we are pleased to provisionally offer you 50 acres of land at Musa, Buniya Raichok, PA such and such, Midnapur. As regards allotment of land, the following terms may apply. The land will be given on 90 years lease basis and is renewable also. The land premium rate. Kindly see this. Land premium rate is rupees 5.5 lakhs. Only per acre. So, my lord, when this was offered to us by this letter of 11th of September 2001, the land premium was 5.5 lakh per acre. And my lord will kindly see clause 4 of this. You have to deposit 50% of the land premium as an acceptance of this offer letter. The possession will be delivered after completion of the full and final payment of the land premium. Then payment have to be made in favor of such and such. Then, my lord, your lordship will kindly turn to page 30. The final terms and conditions will be settled during the execution of the lease deed. Now, my lord, what is under challenge, and I shall show what we have done on the land, but what is under challenge, if your lordship kindly takes a look at page 64. 64, my lord. I'm sorry, 63. My lord. Kindly comes to page 63.
Yeah.
5th February 2008 letter. HDA offered, well, this Haldia Development Authority, HDA offered 50 acres of land for setting up of aluminum and steel based industry at Haldia to Hindustan Steel, your group company, dated 11th September 2009. The same letter they are referring. As per request, board of HDA approved the change of allotment and the allotment was made in favor of Manaksha Limited, the petitioner with your lordship. Possession of 15 acres of land out of 50 acres has already been handed over to you after depositing full payment for 15 acres. You have deposited 50% of land premium for the balance 35 acres land in 2 installments till such and such, which was beyond the validity of HDA's offer letter. You
What
had
is
to
the
deposit
total
it
land?
within 2 months.
What is the total land?
Total land is 50 acres. And the land, my lord, the premium is 5 lakhs per acre. That, my lord, will find in the first, that letter which I showed, 5.5 lakhs. So we were required to pay 5.5 lakhs per acre on 50 acres. We were given possession of 15 acres only.
Okay.
Lease deed was given, executed in 15 acres only. Possession was given, but lease deed was executed on 15 acres.
Why? You didn't pay the other
No,
50%.
because they were not giving that. And I shall take your lordship to those documents. They were not giving the lease deed for the balance. And they demanded 15 lakhs per acre as premium to execute that. And I shall show. But if I may continue placing this letter at page 63. 50% of 35 acres is due since long. Recently, you have deposited a check bearing number such and such, dated such and such, amounting to rupees 96,25,000. Stating that it is the balance amount of land premium of the said land. In this context, this is to mention you that the present rate of land premium is 15 lakhs per acre. As you fail to deposit the land premium within time, you have to pay the full and full land premium at the present rate at 15 acres. And when the balance is assessed at 4 crore 28 lakh 75. So, this is the letter which is impugned in the revocation.
What is the amount that was supposed to be paid as per the allotment? 5.5
into 50. And kindly see. Now, my lord, may I place the last paragraph, my lord? it may be mentioned here that HDS has not given permission for construction of residential complex inside your factory, but we have not done so. As the land is offered to you for industrial purpose, you are requested to take necessary action to demolish the residential building. Now, my lord, kindly sees the next letter at page 64.
Yes.
Well, they ask us to deposit land premium of 4 crore 2875. And in default, my lord, there is a threat of eviction that my lord will find from the last paragraph. My lord, may I?
What was the first deposit made by you?
I'll take your lordship to that. But there are letters which has been exchanged between the parties, wherefrom your lordship will find that initially there was a request from our end to reduce the land premium of 5.5, 5 lakhs per acre. That, my lord, it was considered by the respondent and said that no, we cannot. So, my lord, we have issued a letter asking them to, my lord, afford us installments. May I take your lordship to that? And kindly see page 42. Before that, my lord, only thing, page 39 is our request and page 40 is the rejection of that request to reduce the land premium. Page 30 is after receiving that letter of 9th of September, by this 13th September letter, we had requested them to reduce the land premium from rupees 5.5 acres.
Okay.
5.5 lakhs per acre. Kindly see page 39, my lord. The reason being, it's a very low-lying land and enormous funds would be required to do the land filling. That is why, my lord, we had made that request. But, my lord, at page 40, and the relevant portion is at page 41,
Yes.
but at page 41, towards the middle of the page, your lordship will find that this letter was considered but was rejected. And thereafter, at page 42 is the letter of the petitioner, my lord, under cover of which 10 lakhs was deposited.
Yes.
But two things, my lord, I would like to place from this letter. If your lordship kindly sees the second paragraph, I'm sorry, may I place it from the first paragraph? We enclose two demand drafts raised such and such, totaling to rupees 10 lakhs on UCO Bank as token booking amount for the land. Then the next sentence is important, my lord. We would request you to please hand over the possession of the plot to us by Monday, December such and such, so that we may proceed with the soil testing, land filling, and construction activity. You would appreciate that lack of infrastructure facilities, namely absence of an approach road, would seriously impede movement of trucks carrying construction materials and equipment to our site. We would therefore request you to please arrange for construction of this road immediately, so that smooth movement of such trucks to or from our site is ensured. You would recall that during our last visit to the site, you had agreed to provide us with an electricity connection of 33 kV and regular water supply to the site. We would request you to please expedite these conditions. In the meanwhile, you are requested to please provide us with electricity connection of 250 kVA and necessary water supply immediately, so that construction activity can commence. But all these were necessary in view of the fact that this plot of land was for setting up of an aluminium and steel-based industry. It's an industrial plot of land. So when an authority is allotting an industrial plot of land, the obligation of the authority to ensure that the regular amenities are at least there, which is approach road, electricity and the water connection, those have to be there in place. Short of that, we cannot develop because these are beyond our control. The approach road, the electricity connection, and the water supply. So, immediately, after receipt of that, we had requested them to arrange for this.
Yes.
Now, if my lord kindly turns to page 43, they accord us soil text permission for soil testing and survey work. And kindly see the second paragraph. It is also informed that HD has already taken up the construction of approach road for your project on a priority basis, and it is expected that it will be ready within a short period. Now, my lord, if I may humbly beseech your lordship to once again come back to page 37 for only one thing. Subsequently, my lord will find they have taken a stand that since we have not complied within the timeline of this letter, so our offer will, that land premium has to be paid at the enhanced rate or the prevailing rate of 2000. Possibly they cannot say that. Your lordship will see at page 37, clause 3 is, this offer letter is valid for 2 months from the date of issue of this letter. Now, kindly see page 44, their own letter. This is 21st February 2002, which is after 5 months. The offer was September. This is 21st February. With reference to the above, I am enclosing the revised site plan in the Mousa such and such for the above mentioned subject. As regards the allotment of the land, the terms and conditions will remain same. BD number dated such and such, dated 11 September 2001, issued from this office. So, my lord, in February 2002, they acknowledge that the terms of that letter of allotment would remain the same. Now, your lordship will kindly turn to page 45.
Yes.
Under cover of this letter, in addition to the 10 lakhs, we had deposited 1 crore 27 lakh 50,000. But the second paragraph of that letter also makes an interesting read, my lord. Your lordship will see, we hope that you will take effective steps to provide us water and electricity near our site at your earliest. So till then, there was no water and electricity.
Sorry. Yes. I will respond to them with any next subject. Thank you.
Well, if your lordship kindly comes to page 12 of the writ petition once, I shall show two paragraphs from this. At page 12, paragraphs 9A, 9 and 10, and the sub-paragraphs, lordship kindly sees. The petitioner thereafter applied for allotment of 15 acres of land for establishment of export-oriented unit. That we have pleaded in paragraph 9A. But we were replied to by the respondent that the 15 acres of land which we are wanting is within that, is part of that 50 acres which has been allotted to us. This reply, my lord, will find at page 46. But I'm not troubling your lordship with that. They reply that, my lord, this 15 acres which you are wanting is part of the 50 acres. Now, my lord, in paragraph 9B, we have pleaded that, my lord, on making the full and final payment for the premium for 15 acres, but a registered deed was executed in our favor. Now, my lord, will kindly have a look at paragraph 9D. Now, an export-oriented unit has been set up at the site, at the land. But then paragraph 10A, it has been mentioned that the petitioner has invested huge amount for development and construction of infrastructure on 35 acres of land, setting up an aluminium steel industry. But this setting up of the industry in that 35 acres of land was never objected to.
These 35 acres of land was not given possession.
50 was provisionally allotted. We had made payment. 15, in respect of 15, registered deed has been executed. In respect of 35, possession was given, but the formal the registered deed was not executed.
Where is that letter of possession of 35 acres?
But provisional allotment of 50 was given. That, my lord, is page 37. That is for the 50 acres, entire 50 acres. Possession has been given to us of the entirety, but they are not executing the lease deed for the balance 35, despite receiving the payment of premium as per the original allotment letter. What they are wanting is, they are wanting at an enhanced rate, which is the letter which is imputed. That is the bone of contention. If your lordship kindly comes back to page 14, where I was placing,
Page 14.
Page 14 of my writ petition. But I have narrated what all reciprocal obligations in the meeting of HDA they accepted and they vouched that they would be doing in order to ensure that this industrial plot can be developed and the industry can be functional. Kindly see small Roman 1. But in the 73rd meeting of HDA on 11th of April 2002, HDA was committed to build approach road and provide water supply and electricity up to the factory gate. Then 75th board meeting on 23rd August 2002, it was resolved that HDA would persuade West Bengal State Electricity Distribution Company Limited to install 132 kV substation at their cost within the time frame, then which should, and HDA should share that as a part of their capital. But the difficulty of this plot of land was, but it was being allotted as an industrial plot, but it was a low-lying land. So land filling work was required. For land filling work, vehicles have to come. The approach road was not there. But there was no electricity substation in the vicinity from where I can withdraw. I can draw electricity. But I can draw from the substation. But if the substation is not there, those are the basic amenities which the authority was required to do before they could point fingers at us. There was no water connection also.
You are what?
Now, my lord, we'll see therefore in paragraph small Roman 2 at page 14.
So how you are running your commercial production unit, export oriented unit at?
We had set up. We had set up. I mean, the construction was set up, but it was not operational at that point.
Okay.
Now it is operational. Now it is operational. But the relevant point of time I was placing paragraph 14.
So you have made infrastructure but could not be operational due to the other infrastructures which is to be provided by the HDA. Okay.
Now first is the approach road your lordship has seen in paragraph 14.1. Then 14.2 is the substation. Now kindly see 14.3. This also concerns the electricity connection. 14.3 and 4. Then 14.5, 14.4, I should place 14.4. Even in the 77th meeting of HDA, this issue was not resolved and it was said that this 132 kV supply would be arranged. Not done. 79 board meeting, your lordship will kindly see. Subparagraph 6. Or the cost sharing was deliberated upon between HD and the State Electricity Board. Well, this resolution we have annexed at page 46. All the resolutions we have annexed, whatever is mentioned. Page 46 onwards, 47 onwards, I'm sorry. Page 47 onwards, your lordship will find these resolutions. But first, page 47 is the 73rd board meeting held on 11th of April 2002. And we'll find at the top.
Yes.
And your lordship will find at the top, with a view to encourage industrial development and to attract prospective entrepreneurs, HDA is committed to build approach road, including culvert if any, and provide water supply and electricity up to the factory gate at HDA's cost. So it's an admitted position that these facilities were lacking. If my lord kindly turns to page 49, this is the 75th board meeting. Dated 23rd of August. My lord will kindly turn to page 50, the relevant portion, 75.06. Power supply to future industries. In the 74th meeting of board held on such and such, it is resolved that HDA shall provide water and assist in getting power up to premises of each industrial units. Hindustan Steels have started construction in their allotted plot beyond MCP. Factory close to the Bank River, such and such is enclosed in the area of industry. In view of this, it is necessary to start acting on development of necessary infrastructure in this zone. So, if I may pause here for a moment with my lord's kind indulgence, they admit that necessary infrastructure was not there and they would start work for establishing the necessary infrastructure. Then to start 132 kV substation along with associated lines and a network of industrial water supply pipeline has to be planned. If approved in principle, HDA shall initiate action for fulfillment of these requirements. No, my lord, page 52, my lord, we have annexed a letter issued by the Haldia Development Authority to WBACP, as it was at that point of time, my lord, before merging with WBACDCL. Kindly sees page 52 and kindly sees the agenda and the discussions, the deliberations at page 53. So for 132 kV bulk power supply, which my lord has seen from the other resolutions, kindly sees this the minutes of this meeting, where my lord will find that proposals have been given to draw, my lord, this for installation of this 132 kV station. Kindly sees,
Yes.
kindly sees, my lord, serial number 3 at the bottom of the page, my lord.
Yes.
For installation of a 32 kV substation in this special economic zone to meet the demand of intending array of industries. The Chief Executive Officer HDA will kindly move the Chairman WBACB, while the Honorable Chairman HDA will kindly take up with the Honorable Ministry of Power, MIC Power, Government of West Bengal. Again, 55, the resolution of the 79th board meeting, 77th board meeting, I'm sorry, madam. At 77.16. So my lord has seen that in pursuance of that meeting with WBACB, this resolution has been taken, that they would be approaching WBACB and do the needful.
Yes.
Now kindly see page 56. And here, may I say, from where the disputes started. Kindly see page 56. Before taking your lordship to that, only one thing. Your lordship has seen from all the resolutions which I have placed and also the minutes of the meeting that nowhere the intending industrialists or the persons or the allottees were saddled with any monetary responsibility to install all these facilities, electricity, water, and other. It was all along the obligation of HDA, which they also admitted that they will have to do that. Now kindly see page 56. This is the petitioner's letter to HDA. A joint inspection for providing the 132 kV power supply at our project site at such and such was conducted in presence of representatives from WBACB, HDA and ourselves on 18 February 2003. WBACB informed us that we would be required to pay them the cost of laying an approximately 12-kilometer long cabling, after which they would attempt to locate the substation from which power supply can be made to us. You will appreciate that this proposal, apart from saddling us with the cost of approximately rupees 20 crores, does not seem to hold out much hope of an early electricity connection. You would no doubt agree that this is the responsibility of power service provider to arrange for the necessary infrastructure. Alternatively, to make our Haldia project successful, we have to arrange for generation of our own power, both during the construction period as well as for commercial production. Taking the industrial norm for installation of power generating equipment to be about 3 crores per megawatt of power to be generated, such an exercise would cost us to the tune of 54 crores for the 18 megawatt of power to be generated by us as per requirement of the project. We would like to reiterate that neither expenses for providing infrastructure to the power supply agency nor installation of a captive power plant for regular use were contemplated by us while preparing the project proposal. If we were to consider this now, it would have a serious adverse effect on the viability of the project. As HDA is committed to arrange supply of power at site, we look forward to your good offices to find a way out of this impasse. We would therefore earnestly pray for kindly consider and make a favor. So, my lord, we'll see that I'm sorry.
So admittedly, the HDA was to bear the cost.
Was to bear the cost. In all the board meetings, I had shown your lordship from my lord, the 73rd board meeting till the 77th, and also the meeting of HDA with WBAC. Nowhere any of the allottees were directed to bear.
But this letter also does not say that you have to make payment.
But this was done during the inspection. That's in the first paragraph. During inspection, we were told.
You will appreciate this.
WBACB said the second sentence, my lord, third line. WBACB informed us that we would be required to pay them the cost of laying an approximately 12-kilometer long cable. So, but during this inspection, that had transpired. So, we immediately shooted it. But I take my case to that level that even if the costs were directed to be borne by us in the meetings of HDA, then also we could not have been saddled, because my allotment letter does not say that we have to bear the cost for other peripherals beyond our unit. Approach road, electricity, water connection beyond our unit. Within our unit, I can understand. That is our responsibility.
Yes.
But ultimately, your lordship will see that they are passing the buck and they are themselves not doing what they were obliged to. And it's an admitted position that they were required to do to make the projects viable.
What prompted for issuance of this letter? Was this letter?
The meeting, may I place it, the first sentence? A joint inspection for providing the 132 kV power supply at our project site at such and such was conducted in presence of representatives from WB State Electricity Board, Haldia Development Authority and ourselves on 18 February 2003. WBACB informed us that we would be required to pay them the cost of laying an approximately 12 kV. So in the meeting, this transpired that we will have to bear the cost for laying the line so that the power substation can be relocated.
What is the reply to this letter?
But there is no reply to this. They sit tight on
it. Any other subsequent board meetings?
Yes, I shall show that. Kindly see page 57. That is the 79th board meeting. The relevant portion, my lord, will find at page 58. Kindly sees resolution number 79.16. Power supply to Hindustan Steels. A good number of entrepreneurs have shown keen interest for setting up units in new industrial zone around Mitsubishi factory along such and such. Hindustan Steels have already started construction and is eagerly awaiting, kindly marks this one, and is eagerly awaiting bulk supply of power. In view of the above, it has been decided to install a 132 kV substation to cater for the units to come in that zone. It is not exclusive to me. For all units in that zone, we were allotted only a minuscule portion. It's a big economic zone which they had set up. So to cater to the units, that this substation was required to be installed. Then kindly sees the second paragraph, my lord. A team of engineers of WBACB and HDA has identified the route of proposed HT line, high tension line, which shall be drawn from the existing 132 HT located just outside the HFCL factory to effect power connection to the proposed substation / Hindustan Steels. A good length of proposed HT line passes through KOPT land. HDA has requested HDC, which is Haldia Dock Complex / KOPT, to grant necessary leave permission for construction of the said HT line. Incidentally, the 9-kilometer long line, along with the associated towers, is likely to cost 3.5 crores. Board may kindly approve the actions taken and advise further. Can kindly seize the resolution. Board requested HDC to expedite their permission in respect of cost of HT line. Board advised HDA to approach WBACB sharing of cost, proposing sharing of cost at the rate of 25% and 75% by HD and WBC. So in this resolution also, which is but at a later date, well, subsequent to my letter, they do not saddle us with the liability to bear any cost.
Yes.
And this has stalled the installation of any electricity connection.
But you say that now it is installed as of
2006, the electricity connection.
so you have to pay any cost to that? Did you pay any cost?
We had to bear, but I'll reply to my lord's query on the next step. I'll see from the records and I'm led by Mr. Abrutosh Mojum that he has asked me to hold fort and he'll come, but his matter is going on in his sent a text that it will go until possibly recess. So, but I would be anyways wanting to come back on some other day. May I finish this portion and then will I take my notes kindly. But thereafter,
Before you start, I also put the query that allotment and giving of possession are the same.
But we were given possession.
You were given possession. You have the document that the rest amount of land was also given possession of. This you inquire.
But they have accepted lease premium for the balance also.
Any document was issued because you come to page 37.
I understand because the language is after making payment possession would be. I understand. But in effect, I completely bow down to what is called has been given possession. And
Oh, there is an admitted position.
Yes, it is an admitted.
Okay.
And they've accepted the lease premium, but they are saying that this is a part of that because now you have to pay at the enhanced rate.
Since that was not completed at that point of time.
Yes, that is their case. And our case is we could not have done because of the lacking in the other facilities. So this is where the dispute is.
Yes.
But if your lordship kindly, my lord, takes a look at annexure P10, which is, my lord, at page 59, on 27th of January 2006. My lord, we give the balance, we were requested to give the balance premium of 96.25. Now, my lord, will kindly mark the date, my lord. 27th of January 2006. They say that the balance land premium is 96,25,000. So they still go by that rate of 5.5 lakhs per acre. Initial payment of 10, thereafter 127.
Yeah.
So 137,500 paid, and my lord, they demand a balance of 96.
Yes.
When this letter was shot to us, we had requested them for an extension to pay this balance amount. And thereafter, because we had already made a lot of investment in the project. Pursuant to an order of this Honorable Court, in this writ petition, dated 18th of July 2008, this amount was paid. We were directed to make this payment in this writ petition.
Which amount? 96 lakhs?
96,25,000.
This has been deposited with the registrar?
No, this was paid to them.
Okay.
Paid to Haldia Development Authority. Which is the balance they had demanded. If my lord kindly see the order file.
Which is the order? 18
July 2008, possibly the first order. But without prejudice to the rights and contentions of either of the parties, we were directed to deposit. Has your lordship got it?
Only without prejudice to the
Yes,
yes.
without prejudice, yes. And my lord will kindly look at the order dated 1st of August 2008.
The deposit was made on, in terms of which order? 18th,
18 July 2008.
2008.
And this has been recorded that the deposit has been made in the order of 1st of August 2008.
Yes.
And if your lordship sees the last sentence of the first paragraph, it has further it is further submitted on behalf of the petitioner that the above amount has already been paid. Then thereafter, my lord, directions for affidavits were given. So, my lord, the admitted position as on date is that pursuant to that demand, though we had challenged that, but we have paid that without prejudice, but that we had to pay anyways. But, my lord, subsequently, what had happened is, my lord, they have demanded, my lord, this land premium, enhanced land premium of not 5.5 lakhs per acre, but 15 lakhs per acre. This, in my humble submission, is without any authority and beyond the terms of the letter of allotment.
So you were not challenging the letter dated 27 January 2006?
No.
You have deposited that?
Yes, we were
As per
able to
you, the
deposit that. That is why,
amount
my
of
lord,
96 lakhs odd paid
yes,
is in compliance to the allotment letter.
yes. So, my lord, the position as it stands now, my lord, is that for the entire land, the entire premium has already been paid as per the original allotment. If your lordship is with us on the terms of the original allotment letter is which will govern the parties, then there is no default on our part. But the challenge in the writ petition is, my lord, the demand which is at page 63. I'm sorry, my lord, I should be placing 62 first. My lord. I'm really sorry, my lord. Page 62, if my lord kindly takes. But by this letter, we had said that we had paid this balance amount. So, the next paragraph, please acknowledge receipt and advise the formalities required to be completed by us for the registration of the above land in the name of our company. So, we had issued this letter.
Yes.
But why I place this is because they did not accept this check. Your lordship will see that the check is dated, my lord, 18th of January 2008, which was enclosed under cover of a letter of 2nd of February.
Which letter? Date?
Page 62. The check of this 96 lakhs was paid by a check number 191791 dated 18th January 2008. They did not accept this. Even after their letter at page 59, they do not accept this payment. So, my lord, they do not encash the check. Thereafter, in reply to this, or rather after that, in reply to this, they'll issue a letter at page 63. They say that paying 96 won't do. You have to pay 15 lakhs per acre. That is when we filed the report. We were ready with the check. We had paid them that also. They did not encash it. So, my lord, this honorable court, while taking up the writ petition for hearing for the first time, asked, okay, we have given the check. You encash it without prejudice to rights and contentions of either of the parties. So my lord, this is what it stands today, my lord. The premium as per their initial letter of demand and their original allotment letter has been. But after receiving that, they for the first time contend in the letter dated 5th February that we have to pay the premium.
But this amount was paid on a later date.
But
as per them, the balance amount was 96.25, which should have been paid within
which should have been paid
within a period of 7 days.
Yes.
But that you have not paid, you have sent a letter seeking installment.
So their letter of demand is of January 2006. So my lord, we had paid that in January 2008. Because my lord, at page 60, your lordship will see when we received that letter of January 2006, we write to them. At page 60, my lord, why there was a delay. While, may I place the second paragraph? While we acknowledge that the balance land premium of such and such, 96.25 is due to the authority, we have been unable to pay the same due to an inordinate delay in commissioning of the project within schedule, as power and water as necessary for commencement of the project were not available at our site. Both aluminium and steel being power-hungry projects, the non-availability thereof within the stipulated time had a seriously adverse effect on our project financials. While water connection has been recently installed, power is yet to be supplied by WBC. You would appreciate that we have already incurred a substantial investment on the plant and equipments for the project. We have also had to incur an additional expenditure for drawal of power line to our unit, including expenditure on construction of substation, etc. within our premises. Coupled with the high interest burden due to delay in commencement of the project, the situation has resulted in severe financial constraint for us.
At that point of time, this 132 kV substation was not there.
No.
Okay.
At that point of time, it was not there, but it came in 2006 at a later point of time, not when the letter was issued. Till minute, the setting up of the wires and cables were going.
Congratulations. Uh, 392 3810 3810 again. Extension. Extension. এটা আসেনি ওটা এক্সটেনশন আচ্ছা ঠিক আছে তিনটে লিস্ট করে দিন Just a minute. ওই 12টা টাইম দিয়েছে 12:30 করে 20 মিনিট আর বলবে Yes, Mr. Gupta.
Yes. So we have in that letter we have indicated that why some more time is required because of of these things, my lord. So we have requested that, my lord, to look into the matter in a sympathetic manner, and we'll pay that, but thereafter we pay that finally by the letter at page 62. Under cover of this letter, my lord, we issue the check. They do not accept. Instead, they issue the letter at page 63 and 64. First is a demand of, my lord, 15 lakhs per acre. Second is, if we do not pay, a threat of eviction. So, my lord, we filed the writ petition where the order was passed that you pay that and there will be no eviction. So this is what there is. Could I come back on some other tables? I'm led by Mr. Mojumdar.
Okay. Mr. Choyan Gupta, an advocate for the petitioner, who places his points of argument. He seeks some accommodation. প্রীতম বাবু কবে কন্টিনিউইং একটা ম্যাটার চলবে কত করে ডেট সিক্সথে অনেকগুলো আসছে হবে না সিক্সথ টেন্থ হ্যাঁ কিছু অন্য কোনো টপে নেই তো করবে টেন্থে টপে দিই টেন্থ কি হয় first
It will be on the 11th instead of 10th, subject to my lords.
11th হবে না 11th সেকেন্ড হাফে একটা কন্টিনিউইং আছে 11th কালকের ম্যাটারটা আছে নো অন 10th
On 10th.
supplementary list বার পর
Item number 5.
Lord, I beg to appear on behalf of the petitioner.
But I have the department is pressing out the file, and when he is that I have drafted the opposition and the extension department confirmations.
My lord, today it was fixed for preliminary hearing, my lord. Direction passed in the year 2013. And thereafter, my lord knows if everything is happening. Last. We are prejudiced because we are
12th November 2024 15th November what is the give the drop Mr. Soumitra Bandyopadhyay, learned advocate for state respondents, submits that already the affidavit in opposition has been drafted and has been sent to the department. However, the. When did you send that to the department? Who will affirm the affidavit? Two is prepared and respondent number 2 is to send it again. Respondent number 2 is to affirm the affidavit. He seeks 1 week extension of time. By order dated 14th November 2024, on the prayer of the state respondents, 10 days period was given to file affidavit in opposition. The direction was made peremptory. Be that as it may, considering the circumstances, since the affidavit in opposition is already ready, as has been submitted, please the state is directed to file the affidavit in opposition. 7 days কোথায় গিয়ে প্ল্যান করছি? Second, fourth. You have to file such affidavit in opposition within 7 days. Release this matter after 7 days. Release this matter after a week.
A particular date may be given, otherwise, my lord, they are trying since 2013. That is why I am pressing. Otherwise, I would not have pressed.
File it by within a week.
The matter is written
4th
about-
December. 4th December date দিয়ে দিন. This matter on 4th December.
Can it be on 5th?
5th এর কি আছে দেখে নিন. 5th এ নাহলে এটা পরেও রাখতে পারেন. ওই উইকের 6th 7th 6th.
Great.
Mr. Bandyopadhyay, you just find out and yes, file it. Yes, sir. Within a week. What are time delay?
Item number 6.
Lordship, I am for the petitioner, Lordship. Previous occasion, Lordship, you also grant the time to file affidavit opposition, Lordship, but not doing it. Lordship, may I praying some solution, Lordship? Page 14, I made representation on DM. This one number 2, Lordship. Kindly they consider DM consider my representation and disposed of and pass reason order, Lordship. Page 14, Lordship.
What is the case?
Lordship, the respondent authority taking my land without acquisition, Lordship. That is my case, Lordship. Without acquisition, and they enjoying my land and making Pakka road. That is the case, Lordship. My royalty land, Lordship.
Page 14.
14, Lordship. I made representation of respondent number 2, Lordship. DM.
Read this.
DM
আরে না রে ভাই সবসময় বললে হয় না না আমাকে দেখতে চাও
পঞ্চায়েত অপরচুনিটি দিয়ে
রাস্তা যারা বানিয়েছে তারা করুন তাহলে এইটা করুন ঠিক আছে ভিডিও করুন
ভিডিও রেসপন্ডেন্ট নাম্বার
4
দাও করুন সেটা বরং ভালো
Four.
ওকে
ভিডিও কনসিডার করুন
হ্যাঁ
video Panchayat Samiti executive.
That's my number 4, Lordship. Consider my representation page 14, that 12, Lordship.
Which representation? Page 12 or 14? Which one?
Page 12, my lord. Other
12.
statement. His allegation the Panchayat road, my lord, has been constructed without acquisition.
My
And he is
property.
losing the property, my lord.
My
It is
without
good
acquisition.
consider after giving opportunity of hearing to all the interested parties.
And pass reason order within 3 weeks.
Pradhan and Pradhan.
Jela Porishwar.
Just read the contention of your letter.
But taking, they are considering that making Pakka road. My letter is on their taking money. Acquisition, they do not need not acquisition, Lordship. I'm just.
No, my lord, it is the Pradhan Mantri Gram Saurabh Yojana as it appears from the, my lord, the representation. There is a village road. It has been, my lord, developed by Mora. Now it has been developed by concrete, but he is, my lord, the
taking my land.
দাঁড়া না বারে ভাই কিন্তু বলতে তো পারছো না এখানে যে লেখা যায় পড়ে দিচ্ছি my lord রায়তী সম্পযুক্ত সম্পত্তির উপর দিয়া হরিহরপাড়া হইতে আব্দুলপুর পর্যন্ত যাওয়ার রাস্তা মেরামত সম্পূর্ণ হইয়াছে মোরাম দিয়ে করা হয়েছে অতএব আমাদের এত ক্ষতি হয়ে যাচ্ছে বর্তমান আনুমানিক মূল্য এত উক্ত থেকে মূল সম্পত্তি এত বরাবর হওয়ায় সম্পত্তি হইতেছে মহাশয়ের বিধান নিয়ম অনুযায়ী বাজার দর নিয়মপূর্বক আর্থিক ক্ষতিপূরণ দেওয়ার ব্যবস্থা গ্রহণ করছে আগামী But there is no provision for compensation. If it is developed by the Panchayat authority, the Panchayat will undertake, my lord, for construction by Pradhan Mantri. I don't know what of the project. But naturally, generally, my lord, the Pradhan Mantri Gram Saurabh Yojana is there, and state, my lord, implemented by the state Gram Saurabh Yojana. By developing this land, there is no such prohibition of, my lord, acquisition. If the, my lord, land has been utilized, বলো তাহলে বলে দাও আমি বলবো না আমি বলবো না বলো
Without my compensation, he cannot get them compensation because
বলতে তো পারতাম সেটা তো ঠিক নেই ওর জন্যই বলে দিচ্ছিলাম মাইলটকে যাতে পঞ্চায়েত সমিতি এটা কনসিডার করে হবে না প্রধানকে তাহলে আসতে প্রধান প্রধান নেই পঞ্চায়েত সমিতি ওরাই তো রাস্তা বানিয়ে
পঞ্চায়েত সমিতি
স্টেটের কোনো authority নেই।
জেলা পরিষদ
জেলা পরিষদকে নোটিশ দাও তাহলে।
জেলা পরিষদ
disposed it up by directing the video to consider after giving opportunity of hearing all the complaints. এটাই তোমার তারপর সুবিধা হবে ভিডিও সবাইকে ডেকে দেখবে তাতে তুমি যদি এন্টারটেইন হও
What is your submissions?
district magistrate
District magistrate not
জেলা পরিষদ
no, I am opposing.
So which authority will deal with that? You don't know. Is it district magistrate or Jila Parishad? Which is the authority? Jila Parishad has not been made a part in this.
I made party lordship. They will appear lordship. Yes, occasionally also appear there, but now they escape lordship.
এক্সিকিউটিভ ইঞ্জিনিয়ার হরিহরপাড়া পঞ্চায়েত এটা হয় কোনোদিন এটা কোনো পোস্টই নেই নো ভিডিও ভিডিও তোমাকে বলছি এক্স অফিসিয়াল এক্সিকিউটিভ অফিসার অফ দ্য পঞ্চায়েত তুমি বললো তাহলে এই ব্যাপার পোস্ট করো
অপোজিশন তো দুবার দেননি আপনারা দুবার তো আপনারা দিলেন না দুবার সময় পেয়েছে
কে বলেছে না
জেলা পরিষদ
নো তাহলে জেলা পরিষদ let them come or 10 year lordship of the order upon the jela police no
Who will execute the order? Don't submit as per your submissions. Tell me who will consider the representation. The order of the court has to be executable. Which is the authority who will execute the order? It's not the whether it will go to district magistrate, block development officer, or Jila Parishad. You ascertain and tell me which is the authority which will execute the order.
হচ্ছে ex officio executive officer of the Panchayat Committee. Panchayat Committee is there because therefore I am
Let the video consider that. No? This is an application. This writ petition has been filed for payment of compensation. Mr. Para, Mr. Swansol, an advocate appearing for the petitioner, submits that the representation of the petitioner at page 12, annexure P1 of the writ petition, dated 11 September 2013. The কি বললাম representation কেটে নিন, the respondent number 4 be directed to consider the representation of the petitioner
with all interested party.
11th September 2013. Mr. Soumitra Bandyopadhyay, learned advocate appearing for the state respondents, concedes to such submissions and submits that the respondent number 4, block development officer, Oriyorpara, be directed to consider the representation of the petitioner. In view of the submissions advanced by the learned advocates for the respective parties, respondent number 4, block development officer, is directed to Horialpada, district Murshidabad, is directed to consider and dispose of the representation of the petitioner dated 11 September 2013 within a period of 3 months. 2 months, within a period of 2 months, after giving opportunity of hearing to the petitioner
And all interested.
and is the requirement of appearance of any other authority? No, only petitioner. After
Jila Parishad lordship.
including all interested parties, all interested parties, including the petitioner, by a reasoned order. Petitioner, 3 months from date of communication of this order. 2 months. Learned advocate for the petitioner is directed to communicate this order to respondent number 4, block development officer, Horialpada, district Murshidabad. Since no affidavit has been filed by the affidavit in opposition has been filed by the state respondents, the allegations made in the writ petition is deemed to be not admitted. With the aforesaid observation, writ petition stands disposed. Why is it supplementary? Document. How much, sir? Who is for the state? I will take it up. There are two matters of the other bench which has been listed in the supplementary list. After that, I will take it.
Supplementary list, item number 1.
I am for the petitioner in this matter, my lord. I have informed about the matter to be taken up at 12 by way of email to the respondents, to the opposite parties. They couldn't file an affidavit of service.
A copy of email sent to learned advocate for
the opposite party number 1. The bank.
advocate.
No, to the bank. To the bank. I don't know who is
Sent to-
appearing. The letter is here.
Copy of the email addressed to the respondent. What you have indicated, respondent or opposite party, Karnataka Bank, dated 26 November 2024, is taken on record. Mr. Pratik Prantik Gorai, learned advocate appearing for the petitioner, seeks for it has expired since long.
No, my lord. 3 weeks after reopening, it expires on the Sunday.
This Sunday.
This Sunday.
Submits that the interim order granted earlier on 18th October 2024 has expired on 24th of November. He seeks for restoration of the interim order as well as for extension of the same. None appears on behalf of the opposite party, Karnataka Bank. Let the interim order granted earlier on 18th October 2024. The interim order granted on 18th October 2024 is reinstated and extended for a period of 6 weeks or until further order, whichever is earlier, list this matter after 3 weeks before the regular bench having determination.
Perhaps 6 weeks will take us within the vacation, the winter vacation that will be there. If it for 8 weeks.
8 weeks where we land?
And 8 weeks will land in January.
Period of 8 weeks. More than 8 weeks.
Item number 2.
Yeah. नहीं আউট অফ লিস্ট করে দেবো আউট অফ লিস্ট করে দিও কি করবো আবার কালকে এসে আবার মেনশন কি ছিল এটা দেখো না তারাপদ দাস পাসওভার রেখে দাও যদি আসে তবে হ্যাঁ একটু পরে রেখে দেবো 10 মিনিট পরে পৌনে একটার সময় দেবো
দেবে না। Daily list item number 7.
May I file my reply, my lord?
My lord, this matter is inadvertently appearing today, my lord.
Inadvertently?
Here on 9th December, my lord.
9th?
9th December, which matter? 7th.
May I file my lord?
7 এ রিপ্লাই কি বলছে when there was a direction to file reply
No, no, my lord.
My lord, perhaps a different.
there was
Can I file my reply, my lord? Affidavit and reply, my lord, filed by the state government, but no opposition has yet been filed by the National Highway Authority. The land was acquired by the National Highway Authority with regard to the land as well as the structure.
wait
Point.
state has filed its opposition
Yes, yes, my lord.
when did they file that
When-
you are moving Badaruddin Sheikh
Badruddin said, my lord, on behalf of the petitioner.
appears to have been not even filed who appeared for this state
That's why today I have filed my reply.
this was dismissed for default
That was restored, my lord. That was
Restored.
restored, my lord.
no it who was appearing for this
13th
state
of October 2023. By the Honorable Justice Vivek Chaudhary, as his lordship then was. 13th of October 2023.
state has not filed any opposition
No, it's an order. My lord, is 1
No, no.
117.
No, no, 3639.
It's a
3639.
restoration.
who is for the state Mr. Vishwas
Yes, my lord.
who is appearing for the state
On behalf of the state, my lord.
see there is
Host Dostila. On behalf of the
state has
federal
also not filed there any opposition
body, has not filed.
No?
My lord, I have served notice. Also, kindly see.
দেখুন তো এখানে
Passport 18.
Lordship, kindly see the notice as well as the
দেখো এটা
lordship,
কোনো
kindly
রিপ্লাই
see.
তো নেই
I have also
কোনো
the
অপোজিশন নেই স্টেটে চেক করে নাও नहीं reply to back to
69 of 2016.
none appears on behalf of yes in this one हमने submit
Madam,
for the
on
filed by
behalf of my lord,
Mihir Kundu on behalf of the patient for obtaining who is Mr. Mihir Kundu
I am for the my lord petitioner, Mihir Kundu.
You are not Mr. Vishwas.
Huh?
Who is Mr.
No, well, this is the transfer bill. I have already filed the Vakalatnama.
Okay.
And I have filed the restoration application. That was restored, my lord, by the
Take back your reply.
Vivek Chaudhary on 13th of October 2020.
Okay, notice the Take back your reply.
Let it be kept with the record.
No. No opposition has been filed by the state. What is
Actually,
this?
my lord, I have given a notice.
You take the reply back on the next date when the state comes. If the state upon reaffirmation files the opposition, then the question of filing reply will arise. Otherwise not. If they do not file any opposition, then what is
Well, let
what
them
is about
take the matter, lord, sir. I shall inform.
you are in this case?
He's,
Have you filed any opposition?
no.
You will be filing? Sure.
This time I have given.
None appears on behalf of the state respondents. Miss, copy has been served upon you.
Different copy laws have not been made with the copy. But well, in this matter, well, initially I was made as a party respondent. After lordship, the directions lordship, they added me as a party.
Okay. Now you'll be filing in opposition to the.
The directions lordship, I will file my report in the form of it.
Okay. Miss Monica Roy, learned advocate, appearing for added respondent NHI, seeks to file report in the form of affidavit. Let such report in the form of affidavit be filed within 2 weeks. Exception thereto if any be filed within a week thereafter. List this matter after 3 weeks. Learned advocate for the petitioner is directed to intimate the next date of hearing to learned advocate for the state respondents.
Opposition within 2 weeks, reply 1 week.
Not opposition, report.
Yes, lordships.
Report.
Report.
They will file a report in the form of affidavit and you have been given 1 week time to file exception.
Reply.
Exception.
Exception.
Your lordship, a matter shall appear on.
After 3 weeks. You give a notice to the learned advocate for the state.
I have already given, let's say,
Again. Yes. Again, give it because we have to find out whether they have filed it or not. If not filed, then they have to come up with the opposition.
Petitioner copy din namin just confusion হয়ে যাচ্ছে
কালকে বললে যে পেয়েছি কপি
Item number 8.
Your Lordship, I am for the petition, Your Lordship. Pursuant to Lordship direction, I have already served a notice upon the state. At learned advocate appearing for the state, Your Lordship. Very short matter, Your Lordship. The private respondent has constructed illegal structure over PWD land, Your Lordship, blocking my ingress and egress, Your Lordship. Page 38 is the my representation, Your Lordship. I am praying for consideration of the same by the respondent number 5 after conducting an inspection.
Lordship, my senior Samraj and in this matter is not able to attend the court due to a personal difficulty, and the report that we have is outdated. It's of 2020. So if you could kindly keep the matter next week, we'll come up with a fresh report for this matter.
What is your report?
We had submitted a notice to the private respondent number 11.
Who is your senior?
Amrita Paja Molde.
File a fresh report. Which is the plot number on which there is encroachment?
1264.
1264.
1264. Paragraph number 2. First two line.
So it is Asim Mandol. What is the name of the petitioner?
There are three petitioners. Nur Mohammad Sheikh, Manju Bibi, and Muhammad Ali Sheikh.
Hmm. No, the construction work is at 1254.
Right. It is a land, PWD land, Your Lordship, beside State Highway, and blocking my ingress and egress of my land, my house.
Your land is adjacent to 1254.
My land, they have constructed the land in front of my land, Your Lordship, which is a PWD land. That is my case, Your Lordship.
Hmm. Gotcha. Mr. Ansel, an advocate for state respondent 6. Huh? So the Mr. Ansel, an advocate seeks accommodation on behalf of বলছেন প্যানেল বলছি না তো বলছি শুনো Mr. Ansel, an advocate seeks accommodation on behalf of who is appearing? Amrita?
Shivangi Agarwal. Amrita Panchamal.
Aja Maulik, learned advocate for state respondents. Next week at a date. Next week at a
Let the affidavit of service and the letter of intimation be kept with the record.
affidavit of service filed on behalf of petitioner and the letter of intimation is taken on record. Fourth.
Great.
You take this back. না না রিপোর্টটা দিয়ে দিন হ্যান্ড ওভার করে দিন আমি তো নিতে পারবো না 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 আগে অমৃতা আসুক কি বলছো
Item number 9. 9 and 10. Item number 9 and 10.
My lord, item number 9, my lord, I am for the private respondent, and item number 10, my lord, I am for the petitioner. My lord, my senior advocate Tanmoy Basu, my lord, his father has expired, my lord. Today is rituals, my lord. That hence I pray for at least 2 weeks adjournment, my lord.
father is expired
Yes, yes.
This so and so learned advocate informs the court that the learned conducting advocate Mr. Tanmoy Basu for petitioner in WPA 27298 of 2022 and respondent number 9 in WPA 20293 of 2023. Author father of learned conducting advocate. Tanmoy Basu বললাম না? Has expired. she seeks accommodation of 2 weeks. List these matters after 2 weeks.
Item number 11.
In item number 8, Lordship,
Now here done. Petitioner
I
was informed that you have not come to source.
no, Lordship, I was appearing before court number 17, Lordship. I just rushed.
Okay,
in,
it will
but-
come up. You just find out whether the encroachment has been removed because the report pertains to the year 2020.
Yes.
In the meantime, what are the steps taken? ডাকতে হবে কে আছে পিটিশনারে চলে গেছে তুমি কবে আসছেন এটা
On
4th December. We'll take it up on 4th December.
Lordship, may kindly give me a direction, then it will be easier for me to fetch
He
the
has left now.
instruction.
If you can get the other side, if it is there, get the other
Then-
side, I change the order then.
Then can I come back at 1:15 if I can?
Take him within this period if you can.
I'll try to communicate with him and come.
Come, both of you come, I change the order.
Great.
Item number 11.
11, I'm for the petitioner, my lord. Lordship recalls it is that matter where already an order of unauthorized construction has been made by Howrah Municipal Corporation.
I take the policy into.
Last Friday, Lordship.
This is the division.
Sit
which
down
order,
first. Take some breath and then have me.
Division which order, Lordship. Just the point this order. Lordship.
একটু দাও না দেখি কি অর্ডার
Thereafter, corporation filed the report and we also filed the exception of this report, Lordship. The matter is now pending before the Honorable
So there is no such
There is
stay.
no stay, Lordship. No stay. And
Howrah Municipal Corporation.
On the previous occasion, on Friday, Lordship, if Lordship recalls, Corporation was directed to comply with your Lordship's previous order to file a report as to what steps they have taken. The learned counsel who was appearing came before my lord and said that it will be filing the report before my lord. My lord kept the matter yesterday and it is being taken up today. It was in the list yesterday also. No report has been filed till date. Lordship order was passed in August, if I'm not wrong, Lordship.
August, yes.
Till date, they have not filed. There is no stay. There's no impediment in carrying out the order.
Miss Devjani Sengupta. আচ্ছা না আসুন what is your name? Miss Shukla Das Chando, learned advocate representing respond number 6 and 7. Files a copy of the order passed dated 20th August 2024 in MAT 1399 of 2024, which is taken on record. She submits that in the appeal, report was called for from the Howrah Municipal Corporation, which has been complied with, and you have filed your exception to that report also. You have filed exception to the report before the appellate court also, and exception to such report has also been filed. However, she concedes that there is no order of stay passed in the appeal. Appeal. By order dated 7th August 2024, Officer in charge, Borough 6, Howrah Municipal Corporation was directed. Where is your report?
Lordship, your report is there, Lordship. Mr. Banerjee is coming, Lordship.
Faster.
The appeal was heard on several occasions. Now the matter is running in the list matter in the division bench at number 50. Matter may be heard by this. So, would your lordship be pleased to adjourn this for a week, my lord?
Lordship, they have been seeking for adjournment for several months now. They have not taken any step to get the matter taken to the top of the list. If at all there is an urgency, they would have mentioned the matter and taken a stay order. No stay order was granted. Lordship, Honorable Justice Joymallo Bagchi, when he was presiding the bench, clearly stated that there will be no stay order passed in this particular matter. They cannot refute that right now.
If that be so, my lord, so far, my lord, I understand they are only 50%.
If the report is ready of the Howrah Municipal Corporation, let that be taken on record first. Thereafter, if you can get it heard, then we will decide the matter.
Kindly fixes a date, Lordship, because for 4 months they're taking
Mr.
time.
Banerjee, you are ready with the report?
The report.
File the report. Ashwin.
I see the orders. The appeal was heard finally, and my lord, 14th was the date for passing order.
No stay is there.
No stay has been granted.
They thought they are, but my lord, they are not seen wanted to.
Mere
Sir, are
filing-
you not understanding what I am saying?
My lord.
Since there is no order of stay,
Even then, my lord, their lordships heard the matter on several occasions.
you go on then. You go on. What I am saying is there is a direction of the court to file a report by the Howrah Municipal Corporation. There is no order of stay in the appeal. I am accepting the report that is being submitted. You say that after 1 week, the matter will be heard by the division bench. I am fixing after 10 days, the matter will be listed.
Let it be after 10 days,
Let
my
them
lord.
comply the order of this court. And whatever you have to make submission before the honorable division bench, you go and make your submissions. If it goes in your favor, fine. There are other, I did not say so.
May I get a copy of the report? Then my lord will
Sir,
we'll take exception, my lord. In the meantime, my lord, we'll take exception. My lord, they have also preferred appeal, my lord. Cross appeal. No. The petitioner also filed cross appeal. That is also pending.
That cross appeal cannot stay in the way of this particular writ petition. I have not prayed for stay. I only have filed an appeal. No application has been filed.
Anyhow, they have filed the appeal.
both the cross appeal and appeal are being heard together.
Yes,
They have been heard together.
you have
But
not
there is no
submitted
stay. There is no stay, Lordship. Your Lordship's order has not been intervened with at all.
Now we have no difficulty to demolish. Already 100% deviation is there. We have no difficulty to demolish the 100% deviation. Now, my lord, as there is no stay, we will proceed in accordance with this. Because we are under the threat of the order of this. So if there is no stay, our hands are not tied. Because once we have already proceeded for demolition, but as there was an appeal, we have said the province that we are not going to do it. We are giving honor to the time to the division bench. Now there is the division bench, honorable division bench has not granted any stay. Your lordships have directed me to submit the report. I think there is no hindrance that we will proceed with the demolition.
My learned friends on several occasions appeared before the honorable division bench.
No, I will not.
My lord, so
But
far I
not
understand,
any
my lord,
occasion
there
a stay was passed.
from the honorable division bench.
There was a clear direction.
So filed an appeal for regularization. My lord, kindly see this order, my lord.
Our officers are very scared, my lord. Our officers will now take immediate steps.
My lord, kindly see this order.
Justice,
My lord, proceed to the matter directed. My lord, was pleased to consider this, my lord, regularization.
So,
matter.
Banerjee, I suppose this report is not in compliance to the order of this court.
My lord.
This is in before the division bench. Make it not today. Anyway, whatever report you are going to file, that should be reflected in the cause title of your tomorrow.
Lordship tomorrow. Yes.
So, as your lordship desires, my lord, adjourn
It is
this
in
for
order.
10 days, my lord. No.
Let them
We
come
file
with that
tomorrow.
report first. Thereafter, pass order. Tomorrow. Day after tomorrow. Day after tomorrow. Okay. Day after tomorrow to list.
I'm deeply obliged, my lord. Deeply obliged.
Please.
Supplementary list number 2.
By application.
Take the microphone.
I'm sorry, Malik. But microphone is not functioning.
Microphone not functioning.
This is my application, my lord. And I have come with this divisional applications against the impugned order passed by the my lord additional district judge at Purulia, sitting in tribunal under section 44(3) of the West Bengal State Regulations Act. That is the my lord, the page, annexure B, page 26. Whereas my lord, 44(2)A by the concerned PLLO has already order passed in my lord, miss case number 1 of 2011. Against that, the opposite party has preferred this my lord, the appeal before the my lord, the State Regulations Appeal 1 of 2012 before the my lord, the district magistrate. Now, after my lord, hearing all the matters my lord, and observing this order by passing that setting aside of the my lord, BLRH order, whereas the BLRH has incorporated only in the record of rights that this is a sadharoner ব্যবহার্য. The my lord, land is a pond and also ridge. That pond is also my lord, sotto of the my lord, public, local villagers and public. Now, in the meantime, my lord, soon after passing of the order, then during prior to that, one earlier revisional application has been granted stay for not to proceed any further. But during the pendency of the stay of the earlier revisional application, the district magistrate has already been passed and disposed of this matter by setting aside of the order of the concerned DLLO, who is sitting in under section 44(2)A of the West Bengal State Acquisitions Act. Now, the nature and character of the pond has going to be filled up not long after that. That's why my lord, we have objected of the villagers consisting of the committee, that is the petitioners.
No,
and they
which
have
one is the
raised-
earlier order?
Earlier order is my lord,
13. 8th May 2013. It directed against order number 518. So 46. Single estate acquisition, right?
PO number 1506. 2013. Whereas the ballot, the 25th November 2013, the matter has already been dismissed for default. Soon after that, this appeal has been disposed of by the concerned magistrate. Now, accordingly, the step have been taken by the petitioners before the ballot for restorations of the earlier order passed by this honorable court. Whereas the ballot, that no opportunity was given, no notice was served, but the matter was dismissed for default. In the meantime, they have taken steps for restoration. Now the matter is kept pending. Now at this stage, my lord, the pursuant to the order of the appeal court, now the authority has already been taken step for converting the land. Whereas the under 4C of the West Bengal Land Reforms Act is to be provided that if any pond is to be converted to a vastu, then this sections is to be applicable by the concerned district land and land reforms officer, who is the appellate authority, but they did not do so.
Where is the copy of order dated 31st January 2012?
31st. Well, that BLO order has not been taken with my brief. But the order passed by the concerned BLO. in which the appeal was preferred.
Sir, what is the
Only we are suffering in regard to this disposal and by setting aside of the order of the concerned PLR.
what was the order of the BLRO which was set aside by the additional district judge
Yes, ma'am.
in appeal?
In appeal.
What was the order passed? What was the original order?
Original order, that is the BLR, it has not been communicated to me. It has not been. Your Lordship, my lord, kindly, my lord, allow me to supplement the affidavit, my lord. I have some copies. I have to file a supplementary affidavit.
Passed under section, under the condition of extension granting of that. What would under section 2R of the original.
Serve notice.
44.
Serve notice to the
A.
state. There is no urgency in the matter. Serve notice to the state and
No,
then the matter.
now at this
And
stage,
come
my
up with
lord,
that order. I'm
nature
giving you
and
liberty to
character
file
has been
supplementary
changed.
affidavit.
But I am not saying at this stage regarding this records of rights has been changed. But so far this 3A, my lord, there is the 3, 44.3. That
Give
order has
notice
been
to the
passed.
state.
That
Without the
order has
state,
been
this
passed.
cannot be heard. Chalo.
My lord.
Uh,
But in the meantime, liberty may be given to my lord, to produce the supplementary
on the prayer of learned advocate for the petitioner, liberty is granted to file supplementary affidavit annexing order number 5 dated 31st January 2012 passed by BL and LRO Purulia 2 in terms of section 44(2)(a) of West Bengal Estate Acquisition Act. An advocate for the petitioner seeks to serve copy of this application upon the opposite parties. Let the copy of this application be served upon the opposite parties.
It is
State
already
is a
been
party.
served.
Revenue officer, yes, state is a party. And file affidavit of service on the reasonable date. Is this matter after 2 weeks before the regular bench having determined? Yes. 8. This one.
Daily list, item number 8.
It's very small here. It can be disposed of, your lordship, because ultimately it has to be heard by the executive engineer.
Lordship, there is a
After giving
representation made by the petitioner wherein it has been claimed that the private respondents have made certain constructions over the PWD land. Now, what I find from the report that they have initially conducted some inquiry and it has been found that the construction has been made on the PWD land, but in front of the private respondents' land, but which is creating an obstruction for the petitioners. So now, if Lordship gives direction to the PWD authorities to kindly give a hearing and thereafter dispose of, consider it
And after making a
representation. Yes.
page
Only
38.
representation. Now it is
Yes.
left to the authorities to what they will do.
Page 42 is the last representation. Lordship, I find.
Page 38.
Its writ petition has been filed seeking direction upon the respondent authorities for removal of encroachment
Yes, Lordship.
besides the road in front of plot number 1264 মৌজা উত্তর গৌরা PS Kanna district পূর্ব বর্ধমান. Mr. So and so, an advocate appearing for the petitioner, submits that the ingress and egress of the petitioner has been affected by the encroachment over the land of the PWD roads.
No, actually, Lordship, the construction was made in front of the land of the private respondent as well as certain portion of PWD road, certain portion.
কি বললাম? On the PWD roads. A representation was made before the authorities concerned. However, sorry, he seeks that the authorities concerned be directed to consider the representation of the petitioner, which one at dated
Is 38 and 42.
38.
38 as well as 42.
Dated. What is this date received on?
1st November 2019.
1st November 2019. Mrs. Amrita Paja Moli, learned advocate for the state respondents, also submits that the representation be which respondent will consider the representation? The respondent number 5, executive engineer, be directed to consider the representation of the petitioner. Executive court দিয়ে দেবেন বর্ধমান South Highway Division PWD roads. In view of submissions made on behalf of the learned advocates for the respective parties, respondent number 5, executive engineer, Bardhaman South Highway Division PW roads, is directed to consider and dispose of the representation of the petitioner dated 1st November 2019.
Lordship,
2019
can
in a period of
only record because some steps the executive engineer has
আচ্ছা,
taken
ওনার
some
submission-এ
steps.
Because
there is a report.
মৌলিক submission, consider submissions, and also informs the court that steps has already been taken for removal of encroachment over the government land. Consider within a period of
Lordship, 4
Three-
weeks. 4 weeks because
weeks.
because hearing has to be given, inspection has to be conducted.
4 weeks or 2 months, 2 months time, 2 months time, 2 months time from the date of communication of this order after hearing the all interested parties, including the petitioners, by a reasoned order. Learned advocate for the petitioner directly communicate this order to respond number 5, executive engineer. With the opposite order, repeat
Lordship,
order after.
Huh?
Completion the edition order.
ওইটাতে add করে দেবেন।
Would Lordship,
Affidavit of service finding.
would Lordship kindly take the report?
Not required, not required. Let them take steps.
Grateful. Grateful. My lord, any mentioning? My lord, appeal.
Case number 212 is an application for passing the degree on the basis of the commissioner's report. But in the last hearing on 5th August, commissioner report did not reach here. Kindly direction is necessary. Next is running in the item 75 in the monthly list of law. So it may come anytime. Kindly direction is necessary.
What direction?
Or sending the original side, report has been submitted, original side registered. It is in his office. This has not been transmitted yet.
When the matter will be taken up, let it be in the monthly list.
Same thing has happened in the last hearing also. That time.
Let it be in the monthly list. Okay. They can.
On 5th of October, my lord, your lordship disposed of a GA, my lord, thereby directing the department to carry out the amendments within a period of 3 weeks on reopening of the court after ensuing puja vacation. But due to some personal difficulty, family, my lord, is unable to comply the
We
direction.
mentioned here.
My lord, yesterday it was expired. No. Order the equal order.
Regular bench. Lordship, this is a PLA matter. I am the brother. I'm not a caveator. I live in USA. The citation was received on October 4th of October. So kindly grant me to allow this. এই বছরে
Regular bench item number 1.
Lordship, I beg to appear for the plaintiff in this matter, Lordship. Lordship, I want to leave.
এই মাইক্রোফোনটি কাজ করছে না এই মাইক্রোফোনটি কাজ করছে না
Lordship, I pray for leave to file our wakalatnama.
আচ্ছা
Lordship, I pay for leave for file our wakalatnama. Actually, Lordship, what happened is we ready with the wakalatnama. If your Lordship can see, but no objection is there by the previous advocate on record. The department concern is ki Lordship give direction that we can file our wakalatnama before the.
You gave the no objection from the erstwhile learned advocate.
The Lordship.
What is your name?
Priyanka Gaurai.
Learned advocate Miss P. Gaurai seeks accommodation to obtain no objection of the erstwhile learned advocate for filing press wakalatnama.
Lordship, one indulges
That is
is.
the monthly list of January.
Lordship, one indulges is we
20.
also want to pray for leave to file our.
First, you file the wakalatnama getting the no objection from the erstwhile learned advocate. This matter will appear in the monthly list of January 2024.
Deeply also.
Item number 2.
My lord, my receiver is your lordship had heard on the last occasion.
In item number 2, my lord.
Last day's order.
My lord, in item number 2, my lord, I am appearing for the petitioner number 3. I am appearing for the petitioner number 3. Shamolendu Mitro.
Am I to not know whether I'm audible? First line, both of us submitted I included here, taking my point of nativity that system modification application should be that will go and I will accept that. I'll give away that point.
That is in the
But
virtual
Mylord
also.
Whereas Mylord had taken like this that I am not intending to file any opposition. But Mylord, this has to be
Modification
What do you intend
application.
to do? Tell me.
that I object to Mylord is satisfied that it's not a modification. And of course, today that this is not a modification and Mylord can take it up. So my allotment section was that the modification of the appointment order. Because this basically is the modification of that 26 February order.
Yes. And the regular judge is available.
The order that you can represent the estate, which are not there.
And the modification
Was that to the law. That will if I accept, if I file affidavit in opposition, then I give away to my understanding. I may be wrong. Then I give away to that point. But I think that has been gone down wrongly that I don't think it.
No, there was no such submission.
Yes.
Single satisfied with the modification.
No, Mala, this is not a submission. This is incorrect submission.
Because it is a modification application, then it is not maintainable as per you. If it is not
That
a
could be
modification
before the
application, then
bench
it will-
available. Yes.
Mala, this is not a submission which was made on the last occasion. Mala, your
Ajay, what is happening, Mr. Gupta?
Lordship.
You are
This
not
was not a
allowing.
submission made.
You are not allowing the.
Lordship.
You are not allowing the court to listen to what is being submitted on behalf of the.
Line goes, then my right exactly.
I modify this. Huh? Now, what I am doing is today, since it has been indicated by you, as well as they will also admit that there are some of the applications which are being part-heard, which may or may not have an implication on the present applications. Correct? But as per the determination, this court has determination. So what I am doing is, I am asking the Honorable Chief Justice to give a further direction so that the matters which has been part-heard by the other bench, either that bench will, because everything, if it comes within one fold, I think that will be feasible for.
Yes, my lord.
Sometimes you are submitting that the report was not accepted by that court.
Yes.
This application has been filed for acceptance of the report, and that will be a conflict of decisions. Ashunto?
Malad, your
May I
lordship
indicate,
is
May I indicate, Lord?
Mr.
May I
Malad, your
indicate,
lordship
Lord?
is passing an order,
Malord, may I
Malad.
indicate, Malord?
Malad,
Malord,
this
I
matter
was
is
appealing,
parted
Malord.
matter, Malad.
Malord, may I
This is
audible,
the parted matter.
I'm not releasing the matter. Please take it. I'm not releasing the matter. I'm seeking further direction.
Anna, he's asking the chief.
Malord, kindly
No,
hear me out, Malord.
Malad, your lordship has heard this matter on the last
Malord,
occasion.
am I audible, Malord?
It will remain in this.
Am I audible, Malord?
I'm not releasing the matter.
Am
I'm
I
asking
audible,
the
Malord?
hey, wait a din list.
Malad, your lordship, Malad, may I just
Wait.
Malad, may I just give one order, Malad?
Malord, may I, Malord, may I make a submission, Malord? May I make a submission, Malord? Malord, am I audible, Malord?
That will, sir.
Malord, may I make a submission, Malord?
Only one order. I'll show you your lordship. Malad. Only one order.
Mr.
Malad, your lordship will see this order. Yes,
Learned advocate
consider this. Malad,
representing the plaintiff's respondents.
Okay,
One
One
plaintiff,
order,
one
lordship will
And
see.
1B.
One order, lordship will see. Malad, I
ठीक है order
present this
order
Well, all matters have been released, but Justice Sukato Muzumdar.
Malord, may I indicate, Malord? Am I audible, Malord? Malord, I'm appearing online,
Matters
Malord.
have been released.
No. Not
This is
all.
order which has been passed.
Malord, I'm appearing online, Malord. Kindly,
Learned advocate.
Malord, I was
the
appearing
output
online,
submitted.
Malord.
On the last occasion, that is on 18th November 2024, it was submitted on behalf of plaintiff number 1A and 1B that if the court holds that the present application is maintainable,
আমাকে তো শোনাই যাচ্ছে না
they shall file an
দেখাচ্ছে দেখতে হচ্ছে
affidavit of
এতবার করে
opposition.
বলতে হবে শুনতেই পাচ্ছে না
He seeks for clarification of the order dated 18 November 2024, wherein it has been recorded that the aforesaid plaintiffs will not file any affidavit in opposition. The order dated 18 November 2024 Parakore is clarified to the extent that the plaintiff number 1A and 1B shall file affidavit in opposition if the court, after hearing the learned advocate for the applicant, holds that the present application is maintainable.
Malad, Malad, this one not the submission, Malad. Malad, it's right from my lordship whether they want to file an affidavit.
I cannot take away. No. It is informed by the court officer as well as learned advocates that GA 15 of 2024 has been part heard by Honorable Justice Sugato Mojumdar, and GA 17, GA 15 and GA 18 of 2024 has been directed to be listed on 29th November 2024.
Lordship will also indicate about that order, Malad, 19th of August.
It is Paragraph. It is found that in the aforesaid backdrop, it is seen that some of the IA applications, interlocutory applications, is posted before the other honorable judge relating to the same matter, that is ACR 2214 of 1987. Whereas others are listed before this court.
Malad, your lordship will kindly
To
mention about
avoid-
that order, Malad, 19th of August.
To avoid
Malad, August 19th, your lordship will mention that order also. Why you are making submission? Make a submission to the court. Yes, Malad, your lordship will kindly
I
mention.
have seen that order.
Lordships.
Yes. After that also the court has fixed date on 29th November.
Malad, no, your lordship will kindly mention that order, Malad. The other applications which have been released.
Your lordship will kindly hear me once, my lord.
Has got a jurisdiction.
The above,
Your lordship will kindly. Your lordship will kindly hear me once, my lord.
the applications, আমাদের কতগুলো আছে applications? All the applications being GA and the ACR 2214 of 1987 is before the Honorable Chief Justice for necessary direction.
Malad, your lordship will not.
আচ্ছা একটা জিনিস add করুন।
Malad, your lordship will kindly record my submission also. Malad, your lordship will kindly record my submission also. Malad,
Mr. Gupta
Malad,
submits that. Mr.
Malad,
May I, Milord? May I
No,
make
no.
a submission, my lord?
Malad, there is one submission.
I
I
ask
want to
the
make. Malad,
record
Yes, it is,
officer to
Malad,
take
I
what
put a
is
central
submitted by
lordship.
you. Do you like that your submissions be recorded? Do you like that your submissions be recorded?
Your lordship, Malad.
Then wait for some time. Mr. Gupta, referring to order dated 19th August 2024, passed in G18 of 2024, submits that all the applications has been released by the previous honorable judge to be listed before the regular bench.
Malad, there is one more submission.
আচ্ছা, অঞ্জন,
Malad, there is one more submission.
along
Sir.
with all the applications we place before
Malad,
Chief Justice for this.
Malad, there is one more submission.
এটা এসে গেলে সম্রাটবাবু দেখে নেবেন।
You
সব
don't-
এসে গেলে একটা
Lordship
folder-
will kindly hear me
Malad,
on
there is
once,
one more
my lord.
submission.
Lordship
My
will
lord.
kindly hear me on once, my lord.
My lord, Malad, there is one more submission which I want to make. Malad, that may be recorded. My lord, there is one more submission. My lord, GA 16 has been assigned to your lordship.
Next document.
My lord, GA 16 has been assigned to your
Item
lordship.
number
That is not my submission. My lord, GA 16 has been assigned by another Chief Justice to your lordship. My lord, that your lordship will.
Next.
Item number 4.
My lord, your lordship will not hear this matter. No, Baba. Your lordship is not hearing this matter.
Last day I told you one thing.
Lordships.
You are forgetting that you are a receiver, not a party to this suit.
My lord, yes.
Kindly make your submissions following that.
Yes, my
You are
lord.
here to assist the court.
Yeah, I'm there to
Now
assist.
I have
As an
sought
officer of
the
the
direction from the Honorable Chief Justice. Don't come in the way.
My lord, your lordship. my lord,
Please, I request you.
My lord, this is
I have started with that, but I think it should come in one fold.
my
That
lord,
is what I say.
only one submission your
Let
lordship
the
has
Chief
not recorded.
Justice, let
My
the
lord,
Chief
one
Justice
submission
decide
your
on this
lordship has not
issue.
recorded.
If the suit as well as all the applications be heard by this court, I have no.
No, my lord, one
But
submission
it is
more.
very difficult to follow the implications of one of the court's orders coming to this GA applications. That's why I have asked for further direction.
My lord, only one
Please, I am
submission
not
your
listening to
lordship will record.
Let
Lord,
the direction come, then I will decide.
My lord,
Chalo.
GS
Next
has
order.
been assigned to your
Item
lordship
number
by the
4.
Chief Justice. That your lordship will record.
Okay,
My lord,
not necessary.
my lord, this has been assigned to your lordships. GS 16.
Okay. It is next.
My lord, your lordship, then what you
I am
have
not
done-
hearing right. Let all the matters be decided by the Chief Justice, which of the court is to decide. Then I will take it.
Kindly record that one application.
That will be
Yes, so that is recorded. My lord. Yes, GS 16.
Regular bench it has come.
কত number?
Has been assigned by the Chief Justice.
Only this will go on. They want their choice is what to be included in the order.
My lord,
That is the problem. Kindly record. Sir, পরের মামলা ডেকে চলুন। দুজন মিলে।
my lord, GS 16 has been assigned to your lordship. That your lordship will record that.
Next ডাকুন।
Item number 5.
Yes.
Taken for granted.
I appear for the defendant.
Then, my lord, this is adjourned silent time.
Sir, you will get the order in the website. Because the order, it's the order.
My lord, this is not that is felt, my lord. This is all the my lord, sharp practices being followed by the other side. That is not that part your lordship is not hearing it.
I appear is my application, Lord. Compliance of my Lord's last order, I have already served the receiver,
Who is the receiver?
Lord Miss Shananda Mukhopadhyay.
Where is he?
I have served her
my lord,
through
may I
an
have your-
email, and this is the covering letter which I have sent through email.
My lord, am I audible to your lordship?
Lord, she is there online. She is there.
Forgive me, my lord, there is some technical error here. My video is not
Where is-
coming through. My lord, am I audible?
ওনাকে শোনা
This
যাচ্ছে
has
না
been
দেখুন।
complied with.
ওনাকে শোনা যাচ্ছে না, স্পিকারটা একটু
The pay order has been submitted.
So that I think she will be able to submit, my lord, because she is the one who is carrying the
দেখুন।
My lord, am I audible, my lord?
ALIM.
Good.
Only if, my lord, that exercise is carried, I can proceed with my application.
কি হলো দেখুন আসো বড়
Password. I'll just connect her with telephone if I'll ask her if she is
Yes.
good to present.
I don't know, 6.
Lord, item number 6, 7, and 8, my lord.
My lord.
Inventory has been made, my lord. Today, the articles has been handed over to the petitioner.
amount deposited
Amount has been deposited, my lord. Special officer is present, inventory done. Lordship, only one thing may I just indicate. On the previous date, it was your lordship's direction that the special officer will file a report. The handing over the entire exercise took place in the first half, my lord. We could not prepare the report. I'm seeking only 2 days time. Lordship fixes it on Friday.
no issue
I will file the
Yes, my
report,
lord.
lordship.
Today only the
you
petitioner
have
has
submitted deposited the amount
Yes, my lord.
it is informed by the learned advocate for the State Bank of India High Court branch High Court branch that the dues and charges of the bank has already been deposited.
Well, to that extent, a letter has been issued to the special officer as well as to my advocate on record that the
No,
charge.
they accept that, not necessary. They accept. Ms. Devjani Sengupta, learned advocate representing the receiver, submits that
My lord, special.
The report as directed by this court would be submitted. She seeks 2 days accommodation to submit report in compliance to the order of this court. Is this matter on Friday?
Lordship.
Friday?
Friday.
Friday they direct.
But the only thing, my lord, the time to file the inventory and accounts has to be extended by your lordship because today only the petitioner, being the administrator, has
On
got
that day, you
Lordship. I'm deeply
there is a
obliged, my
prayer
lord.
in the
Yes, my lord. There is a prayer in G18.
I'm deeply obliged, my lord.
no. Since you are satisfied and they have also paid,
Lordship.
so I think yours will it be necessary for him to remain present? Oh,
Deeply obliged.
I don't know, 9.
I was opposing that application for revocation of grant. That by Mr. Mitra. I was in the midst of my argument yesterday.
two you were submitting.
My lord, can you clear also, my lord, that GST should be decided first. My lord, for my convenience, I was doing the paragraphs and the documents from 2.
Yes.
Identical pleading and the same document. Now, my lord, yesterday, my lord has been pleased to take note from paragraph 5 to 12 of their application, which I showed for the purpose that according to them till 2012 December 2006, she was getting a share in the same proportion to her entitlement.
They were supposed to receive 10,000 per month.
According to the will, it is my case that according to the will, both the daughters were supposed to get 10,000 one time, 10,000 each one time, and that they got. Rest all the properties should come to Deepak, my predecessor, subject to life interest of Deepak's mother, that is the testator's wife. There is no dispute that.
No. You are referring to paragraph 9.
Paragraph 9.
After 12 December 2006, what was the share they were receiving prior to that, which has stopped as per them? What is the share?
That is her case. That case she made out that till Deepak was alive, she used to get her 1/3 share from the business of the from the family business.
So as per them, they were getting it.
Yes, it is their
It is not your case.
It is not my case. Now,
Case is that 10,000 has been paid. That is fine, full and final. That is.
I have disclosed documents to that effect. They have also denied the existence and contents of the document signature, etc. Now, 13th December 2006 onwards, she did not get a single paisa. And 2022, she got up from the deep slumber and started pursuing for partition of the property. It is the easiest case to seek partition of the property at any point of time. There is no limitation. So she started by saying that let's partition the property by mix and bound. I'll show that later to your lordship. Kindly come to page 12. Page 12 of the application. It is issued by a learned advocate under instruction received from and on behalf of my client, Miss Meena Das of such and such, I write to address you as under. Sri Sharoda Prasad Roy was the owner of the huge properties, and after his death, his three sons, Chintamani, Sunil, and Gopinath, as his legal heirs and representatives, became the owners of the entire estate of Sri late Sharoda Prasad Roy. Subsequently, by a registered deed of indenture day of 1973, the said entire estate of Sharoda Prasad Roy divided amongst the said Chintamani, Sunil, and Reba Roy, wife of Gopinath Roy, and Dilip Kumar Roy and Arun Kumar Roy, sons of late Gopinath Roy. By and under the said deed of indenture, Sunil became the owner of 1/3 undivided share of the estate, particulars whereof mentioned in part 3 of the said deed of indenture of 1973. Should be 1973. The said Sunil Kumar Roy died intestate, leaving behind his son Deepak Kumar Roy and daughter Meena Das and Rita Kormokar.
Yes.
The name of the wife is not appearing in this letter. Very good. Sri Deepak Kumar Roy died leaving Gita Roy and Sudipta Roy, and as such, the said Gita Roy and Sudipta Roy became the owners of 1/3 undivided share of the estate of Sunil Kumar Roy, and after the death of Rita Kormokar, her husband Probate Kumar Kormokar and son Pronoy Kormokar became owners of 1/3 undivided share of the estate of Sunil Kumar Roy, and my client is the owner of 1/3 undivided share of the said estate. Now my client is very much interested to have partition of the estate of late Sunil Kumar Roy amongst the said Srimati Meena Das, Gita Roy, Sudipta Roy, Probir Kormokar, Pronoy Kormokar, according to their respective shares. Kindly let my client know your views regarding amicable partition of the estate of Sunil Kormokar, since this is among the aforesaid legal heirs within a period of 10 days from the date of receipt of the letter. Otherwise, my client will pray before the appropriate court of law for partition. Now, my lord, I am putting this question to myself. A lady, well educated, she was into her own business. It is not that she has got she not aware of commercial transaction, etc. According to her document, I show that she has her own business, her own investment. 2006 December, she last got her entitlement. 2022, she comes back. First communication to a learned advocate. It has not been alleged in this letter that he approached me. Let's have an amicable partition. She was denied. I threw her out of the house. No such allegation. First communication after 17 years through a learned advocate for partition. Otherwise, I'll institute an appropriate proceeding in the court. Now, kindly test whether her contention, her stand is believable or not. Immediately, well, this letter was issued on 12th April. Immediately on perhaps 21st April, next page, page 14. Through a learned advocate, replied to that letter. Well, kindly come to third paragraph of that letter, page 14. Your client is very much aware that her father, Sunil Kumar Roy, made and published a will, and the said will was duly probated by the Honorable High Court, recording as PLA number 221 of 1995. The probate of the will was granted with the consent and knowledge of your client. In the circumstances, it is denied that Sunil Kumar Roy died intestate. The property of the late Sunil Kumar Roy has been devolved upon his only son Deepak Kumar Roy, and he became the owner of all the properties left by his father. Under the probate granted in respect of the said will of Sunil Kumar Roy, after death of Deepak Kumar Roy, the property automatically devolved upon his wife Gita Roy and his son Sudipta Roy absolutely and forever. In the circumstances, the question of partition of the estate of Sunil Kumar Roy does not and cannot arise. Please advise your client that suppression of material fact is the abuse of process of law, and also abstain your client from taking any legal proceeding against my clients.
Yes.
She through her learned advocate, replied in June, around 2 months thereafter. Page 16. There her stand is that she has no knowledge with regard to that PLA 221 of 1995, and she never gave any consent to the grant of probate.
Yes.
Now, my lord, what I was humbly submitting before your lordship, my arguments have been twofold. One, the case that has been made out before your lordship that she did not have knowledge and she only came to know in 2022, though she is within limitation. That's the case has been made out by my learned senior friend's client. It is absolutely wrong. My lord may be pleased to find from the conduct and from the pleadings the way she had carried on the proceeding. As I showed, if I take her contention to be true and correct without prejudice to my argument that she all along had the knowledge, she gave consent. December 2006, she got her entitlement. 2022, she felt that family estate should be partitioned. No effort had been made in the meantime. Not at all a single allegation had been made against my clients that her request for partition was turned down. And thereafter, generally what we do within a family, first we try to speak to our relatives. If I deny it, definitely I'll go to my London.
Yes. Yes.
Now she says, oh, the entire case made out by her is not at all believable at all at the first instance. Now she says no citation was issued. According to the record, she gave her consent. The signature is denied by her today. Now, if a person, a person who has creatable interest gives consent, then there is no question of issuance of citation. And that is why in natural course, no citation was given. The other important factor, my lord, she had other sister who have also passed away in the meantime, but her husband and her son, they are alive. Despite notice, they have not come forward and contest that yes, the grant was incorrect, the grant was fraudulent. They have not bothered to come before you to appear in this process.
That cannot be a ground. If they don't come up, the others are not.
One of the presumption subject to correction by your lordship, I know the presumption is that they are aware that the grant was made on consent.
Yes.
This the second limb of my argument. I used to question to myself, if the probate was genuine, I'm sorry, if the will was genuine, it can be any option for me. And for me, the answer is negative. The will was a registered one. It was executed by before the registering authority. If my lord be pleased to take note of the submission made before your lordship in GA2 and GA3, not a single sentence has been uttered that the signature was manufactured, was
in three.
Either of that. I was reading from GA2.
Page number 13, para 29.
She is talking about her signature. I'm talking about the signature of the testator in the will. But she has to say that the will is not genuine. He is talking about her signature. Okay. Well, today, so I presume that today I will be pleased to allow GA2. Then the grant will be revoked.
It will be decided after 3.
Not after 3. But I presume that GA2 is allowed to be. The grant is revoked. What will happen? She has to state that the signature of generic manufacture is surrounded by suspicious circumstances. First, she has to out when a person is coming to the lordship after 27 years. She could be out 29 years. First, she has to satisfy the lordship that is feelings. But this is not the signature of her father. For ABCD reason that the will is surrounded by suspicious circumstances. It's a manufactured one. Father was not of sound mind. And kindly taste her pleadings. I will not go beyond her pleadings at all. Kindly check either from GA2 or GA2. Kindly check her pleadings while I was reading from GA2. If your lordship kindly please. There are 16 to 24, I'm sure. At page 6. On perusal of positive, particularly the application of crime, for the past time came to the following fact. The bill and the bill was registered in the office of the under this bill, the DP have requested only property and shares in Miller Space Roy and Company. The two daughters entirely the same was never paid to the petitioner. Deepak Kumar Roy is the sole executor of the said will. A purported consent of the widow of the said two daughters of the said deceased is part of the said application. The said consent records the name of the petitioner. Signature of the petitioner, namely Meena Dash, as appearing at page 8 of the probate application, is false and manufactured. The said signature is not of the petitioner. The said alleged signature of the petitioner is forged. It further transpired that the signature of the petitioner, along with that of Ashalata Roy and Rita Kormokar, was allegedly identified by Arunada's advocate. At no point of time ever, till date, the petitioner had signed any such consent to the said grant of probate. The petitioner had never met Arunada's advocate and had not put her signature on any document in her presence. The petitioner had never signed any document granting consent to the grant of probate of the said last will and testament of the deceased dated 31st January 1979. Signature of petitioner as appearing at page 8 of the probate application is forged and does not belong to the petitioner. Petitioner had not given any consent to the grant of the said probate. The petitioner for the first time came to know about the existence of the purport consent among the said certified copy of the probate application as obtained by from the demand. No citation was ever served to the petitioner. Petitioner had no knowledge about the will left behind by the said deceased or any application for grant of probate of the same having been filed. Paragraph 17. There exists just cause for the probate. 31st January 1979 of Sunil Kumar Roy, the annulled and the bureau. The proceedings obtained probate were defective in substance as no citation was issued to the petitioner hearing, being the daughters of the said deceased. Signature of the petitioner on the purported consent have been forged and manufactured. No affidavit of asset had been filed by the petitioner. The grant was obtained by fraud by making false suggestion and concealing material facts of the case from the Honorable Court. The grant was obtained by means of untrue statement and of the fact essential in point of law to justify the grant. The petitioner has also asserted that inventory and accounts have been filed before this Honorable Court in connection with the said grant. There exists just cause for the probate granted by the Honorable Court of the last will and testament dated such and such of the said deceased in PLA number 221 to be annulled and or revoked. The petitioner had no knowledge whatsoever with regard to the grant. It is for the first time from the later date, 21st April 2021, as issued by the advocate of Kitara Sudipta Roy, that the petitioner came to know about the existence of the said will and the purported grant. Since being aware of the grant, The petitioner had taken immediate steps for filing of the instant application seeking revocation of the grant of probate of will. Petitioner is 66 years of age and immediately after being aware of the grant had taken due steps for filing of the instant application. There is no willful deliberate laches on the part of the petitioner in filing the instant application seeking revocation of the grant. The probate of the said will was obtained by the Roy absolutely behind the back of the petitioner without any knowledge of the petitioner and without obtaining consent from the petitioner, without the petitioner being given notice or being cited. Document act of the part of the in misguiding the honorable court. As a certificate issued by the collector of distributed certificate 1986 would be part of the petition. Whereas several left behind by the disease are mentioned there in the It is the specific case of the petitioner that over and above the proper to mention the certificate that this is left behind several other details in the deed of partition of 1973. Deepak Kumar Roy had intentionally not disclosed all the properties left behind by the same disease. Here is no certified in the except the certificate dated August 1986 by the Comptroller of Resident Central Board of Direct Taxation. Insofar as the petitioner's rights for seeking protection and preservation of the estate left behind by the same disease is concerned, the petitioner reserves its right to make appropriate application. The premises is respectfully submitted that a probate of last will and testament of the same disease dated 30th of January 1979 is granted by the Honorable Court in 1995, the annulled and the revoked. Liberty granted to the petitioner to file variant and affidavit thereof and contest the instant probate application.
Yes.
Revocation has been fought for on the basis of some just cause. What are these just cause? She had not been cited, or otherwise that she had no knowledge. She did not give consent. According to me, since she gave consent, she was not cited. But not a single word that the will is fraudulent. Will is that has to be stated before your lawyer. If I want to seek revocation or if I want to seek contest a grant, I have to state with the execution is surrounded by suspicious circumstances. That I have to say. Unless I satisfy your lordship to that effect, my lord will not be allowed. My lord will not permit me to contest the proceeding even at the time of grant. And the will being the registered one, my lord, it may be issued by your lordship that it was a genuine one. And genuine one. There would not be any reason for my predecessor to accept it. My lord, another situation is that mother died, brother died, another sister died.
Yes.
So there is nobody who adduced evidence from their personal knowledge what had happened in 1979 or 1951 or 1995. So a fantastic way has been chosen after 29 years in the garb of seeking partition of the property that I just came to know of the grant. And what I was doing in the meantime, that between 1995 and 2022, no explanation.
That is that letter by which the 10,000 rupees was.
She kindly to take the supplementary affidavit in opposition that I have filed in GA. I'm sorry, I mentioned 2000. GA2 supplementary affidavit. Declaration dated October 1985. I in cash, according to my father's royal last will. Further, I declare that I have no claim, or rather no further claim, in future on my father's property, movable and immovable. My lord, signature by Meena Dash, 22nd October 1989. Witnesses were Ashalata Roy and Rita Kormokar, mother and the other sister. Now, my lord, kindly turn to the next page.
Wait. Yes.
Kindly turn to the next page, page 7. Identical declaration by the other sister on the same day, where witnesses were Ashalata Roy and Meena Dash.
Yes.
It's her own assertion that at least the lifetime of Deepak Kumar, there was cordial relationship in the family. So this is how the situation was taken care of, according to the father's will. And after 6 years from this date, the application for grant of probate was filed. Probate was granted. So she has denied her signature here as well.
The signature also denied.
Signature, her signature. Her signature. I'll show from her reply to the supplementary application opposition. Reply affirmed by Meena Dash on 1st July 2024, GA2. Kindly come to paragraph 3 and 4.
3.
Paragraph 3. This is Meena Dash's reply to my supplementary. At the outset, I state that the corporate declaration of October 1989, appearing at page 6 of the supplementary application, allegedly to have been made by me, because the revenue stamp is not my signature is forged. I have neither seen nor signed corporate declaration. In any event, there are interpolations made in the same document. The same document is not a genuine document, the entire document is manufactured. She has denied existence and contents of the document. Kindly come to the next paragraph 4 as well. I further say that the purported declaration dated 22nd October 1989, appearing at page 7 of the supplementary affidavit in opposition, allegedly to have been made by Rita Kormokar since deceased, is also a forged and manufactured document. The signature at number 2 under witness is not my signature. My signature is forged. I have neither seen nor signed a purported declaration of Rita Kormokar in any there are interpolations made in the same document. The entire document is manufactured.
Yes.
So, my lord, I can show other paragraphs. Nowhere it has been stated that the signature of Ashalata Roy or Rita Kormokar appeared to have been forged as well. A lady must be aware of the signature of her mother and sister. It has not been stated that here her signature is forged, document is manufactured. Not a single sentence that the signature of Ashalata and Rita Kormokar also appeared to be.
Ashalata is the mother. Mother, Ashalata. In which document her signature is appearing?
Well, I just showed you also the
Mother's signature is also. Yes, Ashalata.
Yes,
Yes.
Now, my lord, with regard to the just cause, why I troubled your lordship so much when we are on the application for appointment of handwriting expert. And unless your lordship is prima facie satisfied with the case that the grant should be revoked and the execution of the will is surrounded by suspicious circumstances, my lord will not be pleased to permit any person having caveatable interest to even seek revocation of the grant, and that is after a long time. My lord, they have alleged that it is a just cause, wherefore they could ascend the will, they could ascend the grant. My lord, only 3 paragraphs I will show from this report. 2018, volume 1, SCC 271. Only 3 paragraphs. Paragraph 13, at page 25. Coming to the ground for just cause, the allegation that the grant of probate was obtained by the applicant in fraudulent manner, as mentioned, the applicant has not come forward to adduce any evidence to prove the so-called allegation of fraud. The signature of Mr. Richard Matthews on the will has not been challenged. The trial court as well as the High Court have recorded the finding that genuineness of the will has not been challenged by the appellant. Moreover, the particulars of fraud are neither pleaded nor proved by the party alleging fraud before the district court. The party alleging fraud must set forth full particulars of fraud, and the case can be decided only on the particulars laid down. Later, there can be no departure from them. Genuine allegations are insufficient, merely because the applicant has made filed allegation in the revocation application that the will by the deceased is void because the will has been sought out by the practice and the will constituted by fraud and undue restraint. It will not have hurt her from providing significant the particulars of fraud and undue restraint, where that will would not give her in having particular. Paragraph 50. Now, all the applicants are eligible for revocation of grant of probate was highly related. But this therefore, as long as the High Court is correct in holding that the applicant's application for revocation of grant of probate is more quickly barred by litigation, as there is no provision under the Litigation Act in the period of litigation for an application of grant of probate. Article 192 of the Act applies the case in Article 147 which provides that any application could be filed within 3 years when the right to apply applies. She said she came to know in 2021, so she obtained the first paper certified copies, and then in 2021 only. To save her limitation, a story has been made out before your lordship. But her conduct between 2006 and 2021 has not at all been explained. My lord, while adjudicating, my lord, kindly test this whether a person is at all entitled, whether such a person is at all entitled to a relief before your lordship. It is absolutely a lie. She has belied before your lordship. My lord, kindly also take paragraph 19. One must keep in mind that the grant of probate by a competent court operates as a judgment in re, and once the probate to the will is granted, in such probate is good not only of the parties to the proceedings, but against the world. If the probate is granted, the operates from the date of the grant of probate of limitation under Article 130 of the Limitation Act in proceedings for revocation of probate. Matter, as mentioned, the appellant was a minor at the time of grant of probate. She attained majority on 9th September 1965. She got married in 1965. In our considered opinion, 3 years limitation is prescribed under Article 130 from the date of the appellant attaining the age of majority, that is 3 years from 1965. Appellant did not choose to initiate any proceeding till the year 1996, that is good 31 years after she had attained majority. No explanation worthy of acceptance has been offered by the appellant to show as to why she did not approach the court of law within the period of limitation. At the cost of litigation, we observe that the appellant failed any evidence to prove that the will was a result of fraud or undue influence. The same will has remained unchallenged until the date of filing of the application of revocation. No acceptable explanation is offered for such a huge delay of 31 years in approaching this honorable court, or approaching the court for cancellation or revocation of grant of probate.
Yes.
Now, so far as the GA3 is concerned, that is for appointment of handwriting expert. Now, when she filed the application for grant of probate, for application for revocation of grant of probate, even at that time, no such application, filing of or seeking of such prayer relief had been filed by her. At the time of hearing, when my lord's coordinate bench Please put forward question whether he found any document of that kind to prove her signature, then only the application had been filed. Now, ultimately, my lord is aware that the court is the best expert. My lord kindly annex for her application to GH3. My lord may be clear. Is my lord at all satisfied with her primary signature?
Yes.
Court cannot be, there cannot be, law cannot be used for abuse, it's an abuse of power. Or after 29 years, I come to the court and I just make a bad allegation and I say that let the handwriting expert be appointed. But this cannot be done. First, prima facie, the court has been satisfied, and then only this exercise can be.
What I understand that the first is that there is a money receipt of 10,000 rupees, which is my client has issued. That in terms of the will, I have received the money. This is one line. The second is there is no allegation in the petition in GA2 or in GA3 that the will is a forged document. The will is forged, suspicious circumstances, challenge to the will is nothing. So these are the two basic reliefs, with argument. But then the third is that I have also not said that the signatures of my sister and my mother is also false on those instruments. If I take these documents, on the money receipt, first is this money receipt came by way of a supplementary affidavit before the court. I have used the opposition denying the money receipt. So this money receipt is one affidavit against another affidavit. So it's one oath against another oath, where he has asserted the money receipt, and this is one I have denied the money receipt. So that money receipt is not an admitted document. Second on this, the probate was not obtained based on that money receipt. Before the probate court, when the probate was obtained, a different no objection certificate is annexed to the probate proceeding. I would have understood if this money receipt is part of the probate proceeding. I am challenging today a alleged NOC, which is before the Honorable Probate Court, when the probate was granted, which according to my learned friend is a separate NOC. They never relied on this money receipt and called it to be a NOC. So the other NOC, which is today part of the court record, I say that signature based on which the probate was granted is not my signature. That is a fraudulent document, manufactured document. So a money receipt coming in today, whence I have denied the existence of that money receipt. To what extent that money receipt can be looked in? Today, a probate has been granted, a revocation has been filed. So the papers before the court are what are the probate court papers? The probate court papers are the NOC, which I say this is not my signature. Now, so this money receipt at this stage, and any event I am in GA3, which I am saying, you appoint an handwriting expert to test the signatures. All depends on my signatures. I was the testing and the report which comes in. Whoever wins the report comes from the government authority. So this money receipt at this stage cannot be looked in. Yes, the second stage is I have not said anywhere that my father's signature is forged, suspicious circumstances and other things. To answer this, I say I need not. Why? Today I say my signature on the NOC is bad. Today I am out of the door. The probate has been granted. So under 263, I am seeking a permission to come inside the probate proceeding. Because today it's like addition of party. Today I am I'm not a party to the proceeding today because I've not been cited. So it's like that. I want an addition of party. If I just even analogy, I'm seeking an addition of party. In addition of party application, I did not cite my defense in the written statement. That I will come. I have to show today I am a necessary and proper party. If I draw analogy. So today I am out of the door. I'm only seeking a permission to come inside. Now, then I have a caveatable interest in undoubtedly. I'm a daughter. I file a caveat and then I get an opportunity under law to file affidavit in support of the caveat, which is my written statement. In the written statement, I take defenses which is available in law, which my learned friend is saying about the suspicious circumstances and other defenses. This I am saying, it's my Lord's pleasure to take up 263 section. This says, I put it down. এটা দিয়ে দে আমার কাছে ইন্ডিয়ান সেকসেশন দিয়ে দেন বের করে দেন আমার কাছে থ্যাংক ইউ এই বেশি দেন এখানে বেশি হ্যাঁ এটা দিয়ে দাও 263 hey you read it my lord ঘুরে যেতে 263 grant of probate or letters of administration may be revoked or annulled for just cause. Now if we read the explanations, just cause shall be deemed to exist where? So explanation is part of the section. The proceedings for obtain of grant were defective in substance, or the grant was obtained fraudulently by making false suggestion or by concealing from court something material to the case, or the grant was obtained by means of untrue allegations of a facts essential, a point of law to justify the grant, or the grant was made useless, inoperative. So, all these explanations, A to E, comes with or. It is not and. So, these are all exclusives. Explanation A is 1, exclusive is 2, there is or. Now we read illustration. This part of the illustration is I. Court, the court by which the grant was made has no jurisdiction. So this goes with regard to the defective in substance. 2. 2 is this fraudulently made by false suggestions. Here I come. The illustration 2. The grant was made without citing parties who ought to have been cited. 3. The will of which the probate was obtained was forged or revoked. So that is also a ground. I'm not saying that I cannot make that ground. But if so these are not, I don't need to put all the grounds. These are all mutually exclusive provisions that have. This or. So if I come under B, I may not come under C. This is in addition to my argument, my lord. If I am allowed to contest the proceeding, then I'll file a written statement. So this stage has, according to my submission, this is my humble submission, the stage has not yet come. But if I can show I'm under B, not been cited, so I need not, which I opened my argument, I need not say that. That stage has not yet arrived. So on this, so this answers the second point raised by Mr. Mukherjee, my lord, that I have not said that the suspicious circumstances, my father's signatures are bad, that I need not. Now, so these are mutually exclusive. Now, on the NOC which is on record, my lord, I say that NOC is a forged document that is not signed by me. Today, if GA3 is allowed, I say that if the handwriting expert says, you know, this is your signature, then I am out of the court. I'm not allowed to enter the arena. But if otherwise happens, if I win, if the report is in my favor, then my signature is forged. So on a fraudulent impression given to the court, you obtain the grant. So I come under B. So today I say, my lord, so far my GA3 is concerned, and oh, sorry, my lord, another argument which is the limitation, which I must address to you. I have cited decisions that this is a fraud on court, fraudulent documents on court, fraud. আমি দিছিলাম আমি দিছিলাম 2018 12 sorry 2008 12 ও কোনটা দেখা ও 18 Justice Arun Mishra. I have cited two decisions, my lord, that fraud unravels everything. With this is the 2008-12 SCC and 2007-4 SCC. লেখা আছে 74812 হ্যাঁ নেই দিয়ে তো প্রিন্টে রে কি আছে No, these are on third these are an expert opinion. On expert opinion, I have given one unreported Justice Bag's judgment. One is AIR 2009 Andhra Pradesh. And Justice Bag. Unreported Justice Bag. This is on forensic. Arekta AIR 2009 Andhra Pradesh. And another is 2009 Madras. So these three were on appointment of handwriting expert and the forensic agency. These definitely they. I'm sorry, my lord, I have marked in my.
Which one?
No, the fraud vitiates everything. Which is
that marked one has already been given to me.
Yes, this is 2008-12 SCC. I think that the one I had cited, 2000, because 2008 is 2008-12. This refers to 2007, must be. No. Paragraph 26. These I have given. That's right. Yes. I didn't cite the second one because if you lordship pleasure to come at para 26, it refers to 2007-4. So I didn't cite the second one. Para 26 and 27. So para 26 has already referred to the other judgment, which is AV Papaya versus Government of Andhra Pradesh. This I am also citing my formula that refer করেছে. Mention the paragraph number, my lord's pleasure. Or
which one?
আছে তো একটা বলছি. The other one is that 2008, 2007. So 2007. না তাই দিব না, তাই দিচ্ছি না. But if my learned friend takes another date time, then I'll retain it back. Because I want to, is it point of fraud? It's only on point of fraud.
No. With regard to fraud, point of fraud, that fraud vitiates everything, that's the settled proposition, my lord,
I'm not citing, then I'm not citing. Because I'm not citing. Because 2008 refer to 2007. Chela. Let's not change the date for, no, yes. And in the 2018 judgment, which Leonard Friend cited just now, my lord, this is that, which says that limitation of Article 137 will apply. Here, in the facts of the case, the lady who applied before the court was a minor when the probate was granted. And then there was a partition suit between the parties. So and this lady became a major immediately. So the partition suit was there. Everybody knew about the partition suit going on based on the probate. And then this lady came after 31 years. So the court held that you were aware. Because Article 137 says that when the right to sue accrues. So the facts of the case says that the lady was aware of the probate when in the partition suit. And paragraph 19 further records, which my learned friend placed, my lord. Paragraph 19 is just at the page 284, that's marking the SCCD. One must keep in mind that the grant of probate operates as a judgment in rem. That para only, my lord. says that the limitation of Article 1 runs from the date of the appellant attaining the majority, 3 years. The appellant did not choose to initiate any proceeding till 96, that is a good 31 years after she has attained majority. Now, no explanation worthy of acceptance has been offered by the appellant to show as to why she did not approach the court within the period of limitation. At the cost of repetition, we observe the appellant failed to produce any evidence to prove that the will was a result of fraud or undue influence. The same remained unchallenged until the revocation of file after 31 years. Partition. And so there was a partition suit between the parties. Yes. So Lordship is on the facts, the paragraph 1 and 2. On the facts of the case. Yes.
1998, the limitation is over.
In my case, if you take that the grant, yes. So if I'm aware of the grant, if
It
I'm
does
aware
not says of date of knowledge, it says when the right accrues.
Right accrues. So when the right accrues.
Yes.
But here in the facts, Lordship will see in the paragraph 2 that Mrs. Fernandez, one of the daughter, leaving behind the will executed in 1959, bequeathing all these assets to Mrs. Matthias. Mrs. Matthias, the original respondent, filed an application for grant of probate, which was granted by the trial of 1960 in OP number such and such. As on date, all 3 children of Matthias were minor, and the appellant appeared though. So your mother, his own mother, obtained the probate, and then there was a partition suit. So she will kindly see. As on date, all 3 children of Mrs. Matthias were minor, and the appellant attained majority in 1965. She filed a suit for partition in 1995, claiming 1/4 share of the property, referred in the will of the deceased of Mr. Matthias. The same is pending. So the lady himself went and filed the partition suit.
But she did not file the application for revocation.
So here is not the case. I have contested any other proceeding. The lady herself went and filed the partition suit. The appellant did not. Now, the first paragraph. The same is said to be pending. The appellant herein did not initiate any action either against her mother or against any other sibling in respect of the will and the probate in question till the year 1996. The appellant filed PNC under section 263 before the District Court of Bangalore seeking revocation of the probate granted to Matthias in 1960, her mother. It means that the appellant approached the jurisdictional court for cancellation of the probate after 36 years from the grant. The district judge dismissed the application both on merit as well as the ground of limitation. The High Court, in this case, upheld the finding of the district judge, was dismissed. It would be relevant to note that the counsel for the appellant mainly contended the citation ought to be issued in the District Court of Chikmagalur, where the immovable property tested is situated. The application for grant of probate did not disclose the name of the appellant or her other 2 siblings. Mrs. Matthias ought to have added all the children as the respondent in the application. The applicant also argued that the grant was Matthias, a result of fraud on court. Per contrast. So, here that same lady went and filed the partition suit. And he was contesting the partition suit since 1960. And then he went and filed the revoke in 1996. And here, there is no such partition suit. I was never aware of the proceeding.
Yeah. Actually, this is distinguishing.
Yes. So here that same lady went and even paragraph 7. You went and filed the partition suit. There were defenses, there were oral evidence laid in the partition suit. So you knew everything. You didn't challenge the grant. The citation was this is a different district because this is the property is in Chikmagalur district. Chikmagalur. So the facts were different. So in those facts, the court said that you had a right, when the right to sue accrues, that you had a right and you knew everything. And so Zanzi, I have not been cited, and in any event, she was a minor on the day when the grant happened. So, and she was not arraigned as a. And here I see it's a fraud. My signature was obtained by fraud. So in that case, that's not the case. That my signature was obtained by fraud, and I say that fraud vitiates everything. It's a fraud on court.
That's so.
So to the facts. So on facts, this case can be distinguished, that in a given situation on the facts, 137 will apply. I know that 137 will apply. So these are my submissions. This 263 is independent of each other. And so, my lord, is 2, 3, GA 2, 3 are heard together, or my lord is
no 3 I am disposing of.
Yes, I think that because the fate of 2 will depend on 3.
Both cannot be taken up together.
Exactly. My lord, even argued both cannot be. The fate of 2 cannot be unless 3 is decided. And my lord,
Which is the order?
I can always say that the original of the documents which are annexed to, I'm still carrying. I'm carrying all the originals because my learned friend said the court is the best judge, which I know, but there are judgments. But I am carrying those all original to be produced before the court.
Then your client is the best person to say whether she has put her signature or not.
Yes, that he has said on affidavit.
If the prayer goes otherwise, what happens to your client then?
But I didn't understand.
If it is found to be her signature, then what happens to?
Yes, that she runs the risk. I know. That proceedings are there. Bharatiya Nyay Abhidhan. Today it's not the CRPC anymore. It's Nyay Abhidhan or something.
Okay.
It's difficult. In event, I'm outside the door. It's like addition of party application, is it? I draw that.
Which is the order by which the court asked that there has been no application
There
seeking?
is no order. I have said that I'm pleading. I have a pleading to that effect. In GA3, there's no such. I have said in the pleading. No. There's no order.
But only during the argument they failed.
It fell. I'm a legacy. Pleading.
This was verbally been asked by the court that no application.
For ID correct, I was personally was also there. Court inquired whether you have made such prayer or not.
My lord, I have said in paragraph 27. In paragraph 27, I have said. That's my statement on oath, my lord. During the course of hearing, it was observed by the honorable. Paragraph 27. Ashun. I have said.
My lord, only thing, it has fallen from the lordship that whether she is aware of the consequences. My lord, kindly please to take page 60, paragraph 37 of GH.
Page 6 of GA3. Page 16 is page 13. ঠিক আছে জানো তো আরে যদি আমার শরীর হয় তাহলে তো না True to my knowledge.
True to my knowledge.
Paragraph 27 is true to my knowledge. That was observed from the honorable court.
True to my knowledge. All the documents have been annexed to paragraph 28. Yes, sir. All the documents have been annexed to paragraph 28, annexure G and H. Up to this, to my knowledge. Now, kindly
Page 29.
Paragraph 20. I say that she has prepared her responsibility on a perusal of the genuine signature in the above document. Immediately, that means 1996 indicate the pattern of my signature remains same. On a conference with my genuine signature with the one appearing at page 8 of the application, that is on the alleged no objection. Here the my signature appearing at no objection and manufactured my signature has been forged.
Awesome.
So I'll kindly bear this in mind as why.
Pleadings are then tried.
This is an application. A master summons to the no, 2 and 9. P3. Summons. P master. This is an application filed by the applicant praying for following orders. You can take it. It will be italics. It is contended by the applicant that she is one of the daughters of the testator Sunil Kumar Roy. The testator Sunil Kumar Roy what is the date of the will? Made a will on 31st January 1979. 79. The said will was probated on 13th December 1995. Provide me the dates of the will probated on 13th December 1995. 13th December 1995. Yeah. On consent of the legal years. The petitioner filed an application in GA2 of 2021 seeking for revocation of the grant. The principal contention of the applicant, petitioner applicant, whatever, is that the consent, the signature of the petitioner on the consent affidavit was not her signature, and such no objection is fake and manufactured. Hence, this application seeking for opinion of handwriting expert regarding the signature of the petitioner on the question documents. Mr. Aniruddha Mitro, learned advocate, appearing for the applicant, submits that the grant of probate has precisely been challenged on the ground that the consent affidavit signature of the applicant appearing in the consent affidavit is not of her. As such, the grant has been obtained by fraud. Referring to section 263 of the Indian Succession Act, he submits that if any grant is obtained fraudulently by making a false suggestion or by concealing from the court something material to the case, it is a just cause for revocation or annulment of the grant. Since it is the contention of the petitioner that her signature was forged on the consent affidavit, the case of the petitioner, if substantiated, will be covered under section 263 of the Indian Succession Act. In order to substantiate the pleadings of the petitioner as above, the petitioner has made an innocuous prayer for appointment of handwriting expert to compare the signatures of the petitioner appearing in the no objection with the signatures with other signatures of the petitioner. Relying on the decision of Honorable Supreme Court passed in KD Sharma versus Steel Authority of India Limited and others, reported in 2008, volume 12, SCC 481. He submits that fraud unravels everything. In light of his aforesaid submissions, he prayed for appropriate orders. in support of his contention, he has also relied on the decision of this court passed in 8. Dr. Sudham. In light of his aforesaid submission, seek for appropriate orders. Which are the documents to be sent? You have enlisted it.
Yes, my lord. There in my prayer.
Have you stated in your application?
Yes, my lord.
Which paragraph?
My prayer, my lord. No objection in the probate application appearing at page 8, which contains the alleged signature Meena Das and other bank records that I have produced with this GA3 application. And also there's another prayer F. I have another bank account, Indian Bank. Now the bank is in custody of certain original documents, account opening form, which bears the signatures, contemporaneous signatures. So if those documents could be brought from the bank and sent to the bureau for comparison, there's additional prayer.
Which are the bank records in prayer A and which are the bank records in prayer F? You have not mentioned of any account number of the bank records?
My lord, these documents are already attached as annexures in this, the original of which I'm carrying. Instance, my lord.
On the contrary, Mr. Shourab Mukherjee, learned advocate appearing for the respondent, submits that the challenge to the grant of probate has been sought for by the applicant after lapse of 29 years. The applicant was aware of the grant of probate. As per the will, the applicant as well as the another daughter of the testator, namely Rita Kormokar, had been paid rupees 10,000 in the year 1989. 89? 1989. Yes.
10,000 each.
10,000 each was. The receipts have been annexed to the supplementary affidavit, which bears the signature of the mother, Srimati Ashalata Roy, as well as the signature of another daughter, Rita Kormokar, which has never been challenged by the petitioner. Therefore, it cannot be contended that the petitioner was not aware of the execution of the will. More so, the petitioner in her application has not challenged the will, which is a registered one. Therefore, since the genuineness or execution of the will has not been challenged, there cannot occasion any issue towards fraudulent activity of the fraudulent act, act of the executor in having the grant in his favor. After receiving payment as per the will of the testator, the daughters have given their consent to the grant. Thereafter, the executor filed application in the year 1995, that is after 6 years. The application for revocation of the will is thus hopelessly barred by limitation. To buttress his contention, he relied on the decision of Honorable Supreme Court passed in Linete Fernandez versus 2018 Volume 1 SCC 271. Before considering the prayer of the petitioner for examination of the signature of the applicant by an handwriting expert, the applicant has to primarily establish that the execution of the will was shrouded by suspicious circumstances. Nothing has been pleaded in the application regarding any suspicious circumstances leading to the execution of the will. Therefore, it would be a futile exercise to send for handwriting expert, for sending the signature of the applicant for examination by handwriting expert. In light of his aforesaid submissions, he phrased that the application for sending the signature of the applicant for handwriting expert for examination by handwriting expert should be dismissed in limine. Para. Upon perusal of it is not in dispute that precisely the application for revocation of the grant has been sought for on the ground that the signature of the applicant on the consent affidavit. The consent affidavit no objection. / no objection is not of her. It would be profitable to reproduce Section 263 of the Indian Succession Act at this stage. Okay? Set out 263. Upon cursory reading of the aforesaid provision, it is found that the grant of probate or letters of administration may be revoked or annulled for just cause. The question precisely in the present circumstances would be whether the consent given by the applicant bears her signature or not. The contention of the petitioner that she has not put her signature on the consent is squarely refuted by the respondents. The matters which has been argued by Mr. Mukherjee, learned advocate for the petitioner, are matters to be decided in the application for revocation. So far as the present application is concerned, it would be convenient to have examination of the signature of the signature of the applicant by an handwriting expert to unearth the truth behind the contention of the applicant raised in the application for revocation of the probate. Thus, in light of the aforesaid discussion, it is ordered. এটা নয় এটা নয় এটা নয় 2 এর নয় 3 in view of the above বললাম না it's ordered that the no objection of the applicant Meena Das in the probate application be sent to the handwriting expert attached to the Central
Bureau of Question Documents, Criminal Investigation Department, West Bengal.
Which does Mr. Mukherjee? It is a Central Forensic Science Laboratory or
Justice Bag's order, it is Central Forensics Science Laboratory.
who usually does this Central Forensic? Okay. ঠিক আছে। And so, and which are the documents for comparison?
Annexure G of in GA3, this is contemporaneous documents relating to Department of Posts and other business documents.
And Annexure G.
And Annexure H, which is my PAN card.
Why don't you specify in the prayer? EFG. Page number?
Page number G appears from page number 46 of that application.
46.
And Annexure H, which is my PAN card, is appearing
And
at page G.
original of documents. You submit those documents. Original of document Annexure G থেকে. Page number 46 to?
46 to 55.
These are all Annexure G.
This is all Annexure G.
55. And Annexure H, PAN card. Yes, sure. Further, the branch manager, Indian Bank, Gauri Badi branch, Kolkata, 70B Raja Dinendra Street, Kolkata 6, is directed to produce the account opening form and specimen signature card and other documents bearing the signature of Meena Das in connection with current account number 205232659192 standing in the name of Sri Durga Enterprise before the handwriting expert.
Lordship will kindly indicate the original documents.
Original. Brankage how original, eh?
Produce the original.
Only trouble you with regard to the documents starting from page 46. Now, since we are on the documents only, page 46, 47. I cannot have any objection. 48. But 49 onwards, my lord, those are absolutely recent documents. Can you check the dates?
No. What they are precisely wanting is to have it before the handwriting expert. Let him examine all the signatures that they have given with the bank account as well as this.
I'm also providing contemporaneous documents.
There will be utter confusion since they have given documents of 96 and the signature is of 95. The expert restricts the comparison within that period only. There will be less confusion in this regard.
The document speaks for itself. The expert would know which documents and which dates I'm providing.
Then under order of a court, there will be utter confusion. Since there are documents of 1996.
Each and every document bears the date. So there will not be any confusion regarding to the date of the document.
There will be an indication in that regard in the order.
Up to which page is the documents of 1996, 95, 96?
Page 46.
46 to?
46, 47, 40.
Let that be.
48. 48.
48 and this one?
49 is also my lord, 96.
49.
50 is 97.
But 51 to 55, my lord, maybe.
It is after
51
after
is
8 years.
2003.
After 8 years, no. So we restrict it to 50. Annexure G এর হচ্ছে 46 to 50. Annexure H is PAN card, which you which is the date of this PAN card, when it was issued.
Just give me a moment.
When was the PAN card issued?
1999.
Let the PAN card be there.
Paragraph 28. Page 13, para 28, I've deleted.
PAN card. PAN card. Annexure H. And when is the document, this account was opened in Indian Bank?
During that time, my lord.
During that time.
During that time.
So let that be proved. অঞ্জন বাবু ওনাদের অরিজিনালটা কি ডিপার্টমেন্টে জমা করবে না যে অরিজিনাল ডকুমেন্টস গুলো? হ্যাঁ কত? না ওরা একটা চিঠি করেছিল ওই কোয়েশ্চেন ডকুমেন্টস এর জন্য কতটা কস্টিং হবে সেটা অ্যাসেস করার জন্য রেজিস্ট্রারকে একটা ডিরেকশন দিয়ে ফর অ্যাসেসমেন্ট অফ কস্ট অফ হ্যান্ডরাইটিং এক্সপার্ট। প্রথমটা initially there has to make a deposition of 5,000 or the cost has to be the learned register original site is directed to collect information from the office to বলে দেবে about the cost of examination by handwriting expert for comparison of the disputed signatures with the admitted signatures of Meena Das appearing in ওই annexure G এর page number such and such R H and admitted documents হচ্ছে bank Indian bank এর account.
Kindly puts a timeline on the bank's
Let's
documents to be
search,
provided from the
yes.
bank. Because all the documents from the bank has to be procured and then we can
Within
provide it.
ওই ব্যাংকে যেটা ডিরেকশন দিলাম ওটাতে করুন within a period of 10 days from date of communication of this order. Learned register original site shall submit report annexing the report of the handwriting expert on the returnable date. List this matter on সময় লাগবে এক মাস পরে ডেট দিন। আচ্ছা
Perhaps in 1 month it will not.
so let the matter go
10
out of
days.
list for the time being.
It has come back after 18. And my lord, I've been thinking day of operation, my lord.
Which order?
My lord,
It is not that executable order. If you want, you can approach. GA3.
but my argument that has been made. Because one of that is
Liberty is granted to the petitioner to press his arguments with regard to GA2.
Parties, well, the respondent.
Both the parties. I know you will be pressing for this point of limitation in the GA2 also. In a sense, you have argued GA2. It will not take much time. At least see if you assemble the order, no issue.
after the order is passed, my lord, can your lordship, my lord, with regard to appointment of handwriting expert, If the court is the basis. Now, after if the court feels that an expert is to be appointed, I cannot stand in the way. But what I try is
What is the requirement?
What is the requirement?
It's in the order if you intend. Try, look. Thank you, Mr. Mukherjee, and thank you. Yes. Keep your
Good afternoon.
Next.
Lord, I appear for the defendant number 8. My learned juniors are in court.
Yes.
And the application of Mr. Medora.
For that application, he was arguing restoration.
Yes, well, for substitution.
One point was that of delay.
One was delay, and the other, there are 4 points taken by them in opposition to my application for substitution. One was delay, and the other main point was right to sue, whether it survives or not.
Yes.
So far as right to sue is concerned, my lord, I have to show your lordship.
What did you?
The case made out in the plaint.
Okay. Yes, that matter. A pension account was
That's
opened.
right. That's right. That's right. Lordship had
7
taken
days delay. PDC due to defect in application, there has been delay. Notice of motion at first time, they have to. The daughters are applicant reside different city. So delay, you say that at first notice of motion was filed, thereafter
yes,
masters
yes,
and the daughters reside outside the city.
Correct. In fact, today I'm carrying those documents also to show that it was filed as it was a firm stamp punched, but then it had to be in the form of a master summons, so therefore it had to be redone. So therefore there has been a short delay of 37 days. And I think, my lord, I have shown sufficient cause, which is why this delay ought to be condoned. So far as my learned friend's argument on the point of right to sue is concerned, my lord, I naturally have to show the case made out by the plaintiff in the plaint. So that is what I was doing on the last occasion. I had placed a few relevant paragraphs. I had shown, my lord, essentially on the last occasion when I argued the matter, my lord, that the plaintiff had worked with the defendant number 8 company for roughly, my lord, a period of about 32 years. And during this time period, or rather when he joined the services of the defendant number company, he had become a contributory member of a staff pension fund in the form of a trust. So the case made out in the plaint is essentially in respect of his claim arising out of pension.
This is contributory members fund.
Staff, he was a contributory member of a staff pension fund in the form of a trust. So he was a contributory member as well as a beneficiary of this trust, which was established in 1959 in the form of a private trust.
Yes.
Now, before I had placed a few relevant paragraphs, my lord, I will not trouble your lordship with those paragraphs all over again. But a few other paragraphs are left to be shown. But before I show those relevant paragraphs, my lord, may I just say one thing? The case made out, my lord, in the plaint by the plaintiff is, so far as this trust and fund is concerned, there was a sum of about rupees 86,10,000 which had accrued to the benefit of the original contributory members who were the beneficiaries. In 1970, this trust was unilaterally amended by the defendant number 8 company, and a whole lot of other members were brought in. And therefore, out of this, my lord, a sum of, out of this 86 lakh, a sum of 40,61,000 was appropriated towards the non-contributory members. So thereby bringing down the corpus, which I would have been otherwise entitled to. And that is the basis for filing this suit.
Does the amount to be paid as pension depends on the contribution of the members, or it
Yes,
is?
in terms of the trust, it does. In terms of the trust, it does. So my lord will kindly come to page 41 of my affidavit. But I have a few minutes, my lord. I hope I can complete placing the relevant paragraphs of the plaint today. Kindly, my lord.
Page 41.
Page 41, my lord. This is part of the plaint. Lordship will kindly take paragraph 28A onwards. May I place these paragraphs, my lord? That under clause 37 of the 59 trust, all trustees are appointed by the said company, and the said company appoints their employees in service as such trustees. The approval of the said company in respect of several operations concerning the affairs of the trust is a prerequisite. The company enjoys as such an extraordinary position vis-a-vis the trust, wielding its influences in its operations. Para 28b, my lord. The said company is the employer of the plaintiff. It owes its duties to the plaintiff in securing to him the benefits of the trust to which the plaintiff is entitled. There is a special confidence reposed in the said company in the matter of contributory pension benefits accruing to the plaintiff. And as such, the company has to act in good faith with regard to the interests of the plaintiff. The said company is bound in a fiduciary character to protect the interests of the plaintiff. 28C, my lord. At this point, it may be recalled that in collusion with the trustees, the said company recovered the monies belonging to the trust and in the hands of the trustees. The said company, it is estimated on a conservative basis, had appropriated rupees 40,61,000 from the trust fund to meet its admitted liability, and the said company is bound to refund these monies to the trust. Lordship will kindly turn the page over. Para 28D. The said company, in its fiduciary character and capacity, had therefore gained for itself a pecuniary advantage. The pecuniary advantage is the said rupees 40.61 lakhs estimated as on 1st of January 1970, plus the gains thereon to date. Gains thereon are above 20% per annum on cumulative basis at quarterly rests, taking into account that the said company over this period has borrowed, the figure is not visible to me, at such and such per annum, compounded at quarterly rests, and that for the years ending on 31st March 1997, 1998, and 1999, the company had paid dividends of 45%, 50%, and 55% respectively. Under Section 88 of the Indian Trusts Act, the said company must hold these monies, including gains aforesaid, for the benefit of the plaintiff and others contributing to the 59 Trust on 31st December 1969, but excluding those who became trustees after 1st of January 1970. Lordship will kindly turn the page over, my lord. Page 43, para 30B, just placing the relevant paragraphs. Para 30B, my lord. In terms of the 59 Trust, membership and benefits were confined only to persons who were admitted as contributory members. The corpus of the 59 Trust was rupees 86.10 lakhs, and there were 50 such members. The actuarial value of the total benefits provided for all these members is represented by the corpus of rupees 86.10 lakhs on that date. Subpara C. By virtue of the amendment of the 59 Trust Instrument on 1st of January 1970, a new class of 600 members were inducted into the 59 Trust, that is, non-contributory members, with effect from the said 1st of January 1970. The pension liability for these members included their services prior to 1st of January 1970. The liability for services prior to 1st of January 1970 is estimated to be rupees 40,16,000. This liability was to be met by the said company alone from its own funds. Instead, this liability was met out of the corpus of rupees 86.10 lakh on 31st December 1969. The trust was not reimbursed any part of this appropriation of rupees 40.61 lakhs from its corpus of rupees 86.10 lakh. Subpara D, my lord. In simple terms, on 31st December 1969, rupees 86.10 lakh were available to meet pensions and liability for past services of contributory members or beneficiaries and for pensions. Consequent upon the amendment of the 59 Trust on the next day, that is 1st of January 1970, the very same corpus of rupees 86.10 lakh also becomes available to meet pensions and liabilities for past services in respect of an additional, different, and new class of 600 members, namely non-contributory members. Lordship will now kindly come to page 47, paragraph 32.
Yes.
Paragraph 32. That in the premises from 1st of January 1970, the company holds in trust rupees 40.61 lakh with gains thereon, as stated in paragraph 28D and shown in the statement of accounts. The amount so held, representing the beneficial interest of the plaintiff, accumulated up to 31st May 1999, will be rupees 5 crore 72 lakh 80,312.95. This amount of such and such has been arrived at arithmetically, taking 31st December 1969 as the base year, when the plaintiff's claim stood at rupees 1,83,963 and 30 paisa only, and the same growing over period with cumulative interest calculated at 20% per annum, compoundable at quarterly res. Now, your lordship will kindly come to the prayers at page 49. The prayers are important, my lord, because your lordship will have to determine from the pleadings made out in the plaint as well as the prayers whether the right to sue survives or not. I will kindly take page 49. I'll just place the relevant prayers. Prayer B, my lord, a decree for declaration that amendments of the 59 trust instrument made on 1st January 1970 are void and bad in law. Prayer C, a decree for declaration that the 70 trust instrument is void and bad in law. Prayer D, a decree for declaration that in addition to existing non-contributory pensions and additional deferred pension, the plaintiff is also entitled to the benefits of pension as a contributory member in accordance with the provisions of the 59 trust instrument, that is ICI India's Staff Pension Fund, incorporating amendments up to August 1959. Prayer E, my lord, a mandatory injunction directing the defendant number 8 to restore to the trust fund all the monies since appropriated from the 59 trust fund, that is rupees 40.61 lakhs, with all gains thereon, as indicated in para 28D and the statement marked I, to meet its obligations of payment of initial contributions to the fund on account of the non-contributory members. Your lordship will kindly turn the page over and see the next relevant prayer, prayer K. The last prayer at page 51. Prayer K. Appointment of an actuary to conduct investigation and to recommend the amount of pension payable to the plaintiff as a contributory member of the 59 trust fund. Two more prayers, my lord, on the next page, which I'll place, my lord. Prayer L, my lord, which is crucial because it's a monetary claim being made by the plaintiff in the plaint. Prayer L, a decree for a sum of rupees 5 crore 72 lakh 80,312.95 against the defendant numbers 1 to 8, and a consequential prayer, prayer M, interim interest and interest on judgment at 20% per annum on the sum of rupees 5 crore 72 lakh 80,312 and 95 paisa from 1st June 1999 till the date of payment. So, my lord, to summarize, my lord, two broad categories of prayers. One is, my lord, certain declarations with regard to, my lord, the validity of the 79 trust and the amendments made to the 59 trust. And consequentially, my lord, a monetary claim. So bottom line, my lord, is that the plaintiff's claim before this court, my lord, is a monetary claim. And therefore, my lord, the right to sue must necessarily survive. Because if the plaintiff had received this money pursuant to a decree of the court, then this money would naturally become a part of his estate, which would therefore, my lord, be inherited by his successors who are before your lordship today in the form of his 3 daughters. I will also, my lord, on the next date, my lord, place relevant judgments in support of my contentions and submissions. My lord, I think I should stop today, my lord. I'll continue on any day, my lord, subject to your lordship's convenience.
Mr. Rishat Medora, then advocate for the applicant. Same, due to paucity of time, hearing could not be concluded. Bolun. 12th
December.
12th. First day.
Very well.
Your lordship is fixing it on the 12th of December.
Yes.
Yes. Well, would it be your lordship's pleasure to fix it at a particular time so that we get a substantial amount of time and the continuity is maintained.
আচ্ছা ওদিন এসে যাবে প্রথমে আসবে আমাদের সেকেন্ড হাফে ফার্স্ট ম্যাটার দিস উইল বি অন দ্যাট ডে দেয়ার আর নো আদার ম্যাটার্স
Very well, my lord.
probably this will be taken up and first.
Very well. Deeply obliged.
Most grateful, my lord.
What if to file a reply, my lord? That's item number 12, my lord. Now, this matter will probably be taken up tomorrow. The only urgency is that, my lord, this is an application, my lord, for transfer of the suit which is pending before my lord to another court, my lord. Now that in that suit, my lord, there is an order, my lord, there will be no further extension and the matter is coming on the 9th. If my lord fixes the matter on the
origin side.
Origin side. Item number 12. My other side.
Next matter, my lord, pleadings are, my lord, we're both carrying out pleadings. The affidavit opposition can be taken on record at the affidavit.
কি কালকে হবে tomorrow
Tomorrow, my
I
seniors are.
This much can be done if it be fixed for hearing on Monday. My lord can take these on record.
then on Monday I'll take it
My lord, kindly fix it on Monday.
এটাকে নোট নিয়ে নাও মানডেতে মানডেতে লিস্ট করে দেবো
এটা নটের অর্ডার করে দিই এই মান্ডির matter.
what
My lord, I only prayer is to keep it on Monday because my leader, my lord, Mr. Shumandar, has some difficulty, my lord, in this week.
so by ওটা ডেট দিয়ে মানডেতে এটাকে অ্যাপিয়ার করো করা যাবে না
Affidavits we take it on record with the original affidavits.
Not.
Original affidavits we take. One line is sufficient, my lord.
one line is very insufficient
Sufficient.
on the prayer of the learned advocates for the respective parties is this matter on Monday
And the affidavits
Affidavits,
we
my lord, that
take it on
line
record. Opposition and reply. And that would be sufficient. Sure.
on Monday
I would like this in the same.
ডেটটা দিয়ে দেবেন পঙ্কজ